Objections?
That's right, my lord. That's right, my lord. That's right. And my lord, here the petitioner before your lordship uh, was tried and subsequently he was declared as foreigner by the Foreigners Tribunal Morigaon. And thereafter, my lord, he filed a review petition there, and that was also dismissed. And as against that, my lord, he filed a
Yes. Yes.
he filed a writ petition, my lord, and the writ petition, my lord, that was also dismissed. And after dismissal of the writ petition, he was taken into custody, and he remained there for about 2 years, and thereafter he came out. And in between, my lord, he engaged a counsel to file an SLP, and the SLP was subsequently withdrawn, and an observation has been made that if he fails here, my lord, he will approach the apex court again, my lord. That observation has been made. And thereafter, my lord, the present review petition has been filed. And here, my lord, the ground of review is this, my lord. We could not annex some of the important documents, my lord, at the relevant point of time. And subsequently, my lord, we have procured, that is number one, my lord, that is a land document of 1957, 56, 57, and then 57, 58. And thereafter, my lord, in some of the most important voter list connecting the parents of the petitioner, my lord, those were also not filed at the relevant point of time. So here about, my lord, now around
But that is something which you were required to do at the
around 12.
at the tribunal stage. What is the mistake in our order?
My lord, that's my lord. That is why, my lord, what I am thinking, my lord, that my lord, this is one of the deserving case, my lord, for remanding the matter to the tribunal, my lord, so that the documents which we have annexed here, my lord, all those documents can be properly scrutinized, even if necessary, in accordance with the provisions of the Evidence Act, my lord. And document which I relied, my lord,
only few names, not all names.
and there are 2 or 3 reasons, my lord, for which the earlier petition was dismissed. And that was, my lord, rightly dismissed, my lord. Rightly dismissed in a sense, my lord. One of the ground is this, my lord. The petitioner could not produce a single document showing the connection of the parents, my lord. So far the voter list is concerned, because it was averred in the last para, my lord. For a moment, my lord, I am, my lord, relying, my lord, page 118, my lord, 118.
What is that?
Judgment.
Of the judgment, my lord.
Please, okay.
118 of the judgment of this on our court, my lord, impugned order. Para 31, my lord. According to the evidence of the petition, my lord has got it, my lord.
Yes, yes.
According to the evidence of the petitioner, father had expired in 1989 and mother had expired in 1991. If the petitioner was born in 1965, 66, he would have become eligible to cast his vote in 1987, where he was 21 years of age. But we do not find a single voter list or any other documents where the name of the petition, name of the above 3 persons, namely father, mother, and a son, appeared together. And there is also no voter list where the name of his son and mother has appeared together. My lord, that was the correct observation has been made. At the relevant point of time, my lord, that we have given a my lord, voter list. In that voter list, only petitioner's name was there, because at the relevant point of time, if anybody apply for the certified copy of the voter list, only his name has been given in the voter list. But subsequently, we have applied certified copy of the other family members, including my father and mother, and that had been procured, and we have annexed, my lord. That, my lord, will find. at page 55 and 59, my lord. Fifty-five.
55 to 89. It wait, 50.
55, my lord. 55, my serial number will find a Razak, my lord, his father, and Ayesha Khatun, his mother, my lord. Then his name, my lord, page 57, my lord, will find because all the family members are there.
59 also.
59, my lord.
Same year. Together they don't give.
59, my lord. A Rashid,
One of them.
son of Razak. Here, my lord, will find 3 certified copy, my lord. The same family, you all also will find the house number is same, serial numbers are chronologically given, my lord. Entire family members. So here, my lord, will find that father names, mother names, and other family members' name, including the petitioners, is also there. So, my lord, in the impugned judgment, my lord, page 31, that observation that was correctly made, my lord, there is no, my lord, ambiguity to that effect, my lord, because at that time, my lord, I could not produce. Only one document had been produced that was containing my name. But here now, my lord, I have found out this documents, my lord, parents' names, other family members' name is there. That is one of the grounds. But second ground, my lord, will find regarding age discrepancy, my lord. Regarding age discrepancy.
Para 60.
Yes, my lord, para 16. Para 16, page, my lord, 113. My lord has got, my lord.
Yes.
Yes, my lord. Para 113, page 16.
No, no, para 60.
Para 16, my lord. Page 113. Proceeding to the exhibit, we find that exhibit co. It is a certified co. It is a certified copy extract of the voter list on 65 in respect of the Lahorigarh constituency. Here, out of the 4 voters, 2 voters named so and so. Then Abdul Razak, his father, and Ayesha Khatun, mother. And here the age has been mentioned, my lord. That is 28 and 40. Now, the observation has been made, my lord, in para 17, my lord. Because the father's age is 28 and mother's age is 40. Therefore, the learned court has considered that in unreasonable one. Because of those days, my lord, the boys, the husband's age is 28 and wife's age is 40. Is seems to be unusual, my lord. That is why it was, my lord, not believed. And here, my lord will find peace, my lord.
47, 49.
Yes, my lord. Page 33 and 45. My lord. First of all, my lord, I am again showing the same thing, my lord. Page 33. Page 33 is the voter list of 1965, my lord. My lord, second name, my lord, Abdul Razak, is, my lord, 28 years.
It's 35.
And wife's name is, my lord, page 35, serial number 4, my lord. That is 230. Ayesha Khatun, page 40.
It's 40.
Page 40. Is 40. Page 35, my lord. Last from 1.
In view of this, the doctor will. Corrected over.
And in last occasion, my lord, the same voter list, my lord, page 35, that was produced. Page 36, my lord, that was the same voter list, but at that time, my lord, this copy has been produced where the serial number, my lord will find 224 Abdul Razak, age 28, and then my lord 2232 serial number 232, house number same, my lord, 40, Aisha Khatun, 40. So this was annexed at that time, my lord. At the time of filing of the writ petition, my lord, this document was filed, and here, my lord will find there was a missing of the the DSD scheme is there, and that was, my lord, there. That's the scheme, my lord, we do admit, because we cannot have any hand on the same. Is certified copy given by the election authority, my lord. They have given this age, but subsequently that has been corrected. That I will come to know, and I have annexed the same. And before that, my lord, I want to show the voter list of 1970, my lord. That is also, my lord, will find at page 39. Page 40, my lord.
Just a minute. Just for the division. This is mentioned here. Important distance in the law. Correct. Says. Very. It's like a statement here. But the benefits are not put on it. It's not great. Is that this?
Mr. Chaudhary,
My lord.
this, you're challenging the order which was passed on 2018.
2018 order.
My lord.
What is the explanation for delay? Did you file any application for condoning the delay? No.
My lord, in fact, my lord, along with this review petition, my lord, we thought that there was a delay, my lord. And for that purpose, my lord, we have filed a petition under 5 of the Limitation Act, my lord. That was filed. And the copy has also been supplied to the other side. And subsequently, my lord, the call has come from the registrar saying that there was some defect. So accordingly, my junior and they went to the registry and they said, you take back this. This is not necessary.
The filing or reversed.
And filing slip, I am having that was returned.
It's possible.
Maybe I don't know, my lord. Maybe because the
of
writ petition, normally, my lord, in the writ petition, there is no limitation, my lord. There is no limitation.
No, delay
I don't know, my lord. And that is why, even if the writ petition is filed, my lord, there is no conversion petition is not required. Maybe because of that also, I don't know. But that was filed, that was
Because
returned.
writ petition is also under 226.
Because after all, my lord, the writ petition under 226 of the Constitution of India, my lord.
Review of writ
And we
petition
have
also-
seen, my lord,
Review of writ petition
that
also under
against
226.
any order, my lord, against any order of the tribunal, since there is an appellate authority, and therefore writ lies, my lord, and the writ petition, my lord, normally no condition petition is filed, and this is how the matter is going on. Probably, my lord, because of that.
No, you see, you have made your statement that paragraph page 25 of the 25 of the review petition.
Page 25, my lord.
Yes, paragraph Roman 7, the last line.
Yes, my lord.
You said that you filed condonation petition on 3/3/25.
My lord.
But since we do not find any condonation petition, that's why we're asking you.
No, that's right, my lord. He's right. Your lordship is perfectly right, my lord.
Because both filed together.
Because both filed together, prepared together, filed together, my lord. And that was subsequently. That is why your lordship is correct, my lord, in asking the same.
Now, so far as the finding of the opinion of the tribunal is concerned, writ lies. And the writ, normally in such kind of case, it's entertained by a division bench,
My lord,
like this court.
my lord,
But once a decision is reached,
My
this way or that way,
my lord,
the matter ends there.
my lord,
Next step will be for you to approach the apex court,
My
to agree. But then here you have chosen to come back to the same court as a review.
my lord.
So how do you say that delay will not, there will not
That's-
be any question
That's
of
why,
the
my lord,
condemnation delay?
that's why, my lord, the limitation petition has been filed, my lord. We filed it, my lord.
Maybe there was some suggestion from the court. also.
At the first instance against the tribunal order, of course, there will be no question of delay.
My lord,
It's a writ petition.
my lord,
But the order has been rendered in the writ petition. Now you are coming back to review that order.
my lord.
So why should not the principle of limitation apply in that?
No, that's why, my lord, I am not disputing it, my lord. I am fully agreeing with your lordship, my lord.
What is
And
your
that is why it
explanation?
has been filed, my lord.
What is your explanation?
The review-
Explanation is, my lord,
review is
immediately
also
after dismissal of the writ petition, my lord, he was taken back to the custody. He was in detention camp for 2 years, my lord. And in the meantime, my lord, the assembly was filed and that was subsequently the withdrawn. The liberty was granted, my lord. And then he came out from the jail and there was some miscommunication and all, my lord. And then he also engaged a counsel, my lord, named there, my lord. And he says his matter has come back to the High Court and we have to file a review petition. And you are under impression, the review petition has been filed. And when, my lord, he was suspended because he was a BHC teacher, my lord, and he was about to retire.
dismissed
And
from
then,
court.
my lord, suspension was there. And after suspension, my lord, suddenly, my lord, dismissal order came. He was dismissed from service. And whenever he was dismissed from the service, and it was, my lord,
In media.
my lord, in the media, there was a media. And from the media, my lord, from the TV, my lord, he has come to know that he has been terminated. And then after 3-4 days, my lord, he got the termination order. And then he contacted the council. And council says that we need to file a review petition. By this time, my lord, time has been elapsed, my lord. Then he came to the, my lord, council for consultation and suggestion. And then, my lord, we have said the consulted with the same.
Review the petition is also under 226, so not change. When the power of review is under 226 होते हैं, तो doesn't matter the
And regarding review, my lord, there was a number of judgments, my lord. The review petition was filed. Some were dismissed, some were allowed, some were, my lord, sent back again for fresh trial.
Review is also under 226.
And the review petition is filed also under 226, my lord.
Yes, Mr. Sharma, what is your response?
I'm sorry, in this case, what happened with some escape handicap because our name was not shown in the matter first list. So the file was not with us. However, matter I have control of judgment of this noble court matter. Matter the originally, your lordship may kindly see the judgment of this honorable court at paragraph 26, my lord. Obviously, my lord,
Noticed. Yes, we have noticed.
yes. Then, my lord, paragraph 31 also.
Now,
Para 10, my lord, para 31, 32, and para 10, my lord. Para 10 of the. So everything has been discussed before this, by this honorable court while passing the judgment, my lord. And my submission is that, my lord, there is no error apparent to face the record to review the judgment. And this is settled position of law, my lord, by this honorable court as well as honorable apex court. And in the high court, while in the certiorari jurisdiction, because this is review of the, my lord, order passed in the certiorari jurisdiction. So this is an extended part of the certiorari. So, my lord, the once in the certiorari jurisdiction, this honorable court may not take new documents or new evidence because it is not a, my lord, appeal. Had it been in the tribunal, my lord, they could have submitted new documents. But it is not in the tribunal or high court, my lord, at least after it during writ jurisdiction. This is extended part of the writ, my lord, here in review. And of course, my lord, even though there may not be, my lord, there is contradictory, my lord, opinion, whether the, my lord, limitation application will be applicable or not. This honorable court has given some judgments, my lord, where it is said that it is necessary. And so, my lord, in some of the cases, review petitions, some of the petitioners, they file limitation petition under Section 5 of the Limitation Act. And those are allowed or rejected.
We won't say, comment anything because he's showing us with the high court
Yes.
seal.
But
Therefore,
this, I don't understand, my lord, what is that?
no,
because-
whatever be, but
And, my lord, that's why, my lord, I'm not saying that whether it is necessary or not, that is not an issue. Only issue is, my lord, there must be at least in the review petition, there must be a, my lord, statement on what basis, why this delay and lapses occurred. I'm not asking that, my lord, limitation petition must be there, condemnation petition must be there. But, my lord, the statement on why this delay and lapses occurred, that should be there in the petition. And your lordship may consider that if your lordship finds that that is, my lord, enough to, my lord, condone that, my lord, they accept the application, then your lordship may accept it. But there must be a statement. Without a statement, your lordship may not take it. That is my submission, my lord. Because the delay in lapses on the part of the petitioner, that has to be explained in a review petition itself. If it is, but that is not there. So unless it is explained in the review petition, my lord, your lordship may not accept it. Because this opinion, this judgment was passed in the, my lord, 27/9/2028, 2018, my lord. And in between, my lord, what happened, that cannot be known to us because if it is not stated in the review petition. And apparently, my lord, on merit, I will submit that, my lord, there is no error apparent in the face of the record. The judgment, my lord, of this noble court passed on 27/9/2018 has deals with each and every aspect of the my lord, record, whatever was available. And secondly, my lord, it is not the court, my lord, tribunal. The tribunal opinions, if the learned, my senior friend has, my lord, the petitioner wants to go for, my lord, review of the original tribunal's opinion, they could file they have to go to the tribunal, my lord. There they can submit new documents, they can, had it been, my lord, within the limitation period. Because there the review provision was there. Initially, my lord, my submission will be if the opinion is found to be not faulty, or if they found that there are some documents which could not be submitted in the opinion during the time of trial in the tribunal, they could have filed review in the court tribunal itself, because the provision of review was there in the tribunal, but they did not prefer it. Then they prefer a writ petition, my lord. After dismissal of the writ, they prefer SLP. SLP was withdrawn, then they come back to file a review in this honorable court. The dishonorable court, my lord, it is and dishonorable court in numbers of judgments, my lord, where it is settled. C1 to C1 settled that in either in writ petition or in the review petition also, while by exercising to my lord certiorari jurisdiction, dishonorable court may not take new documents or new evidence. That is settled position. I can submit some judgment on that point. Podium, keep it, yeah.
Before the third.
This is the thing. This is the pretty. This is. This is what it was. Any kinds of new petitions. In the new petition, it says that you now as well. Was rejected. This one was once this is basically instructed, come back to this one. If you answer by the mistake, this has to be instructed by them. And this
Okay.
later. With the panic of the words. This new petition. This is that his father is. Yes. In some documents, this is the name, some point, this is that he was taken in the petition. So now you will give this to this petition. And here, what they put it was. This question will be interpreted, so and so I will. Yes. This was no point. So I not want to know how this. Check it. It's investigated. You are not allowed due to visit. You have a copy of the petition for special leave to appeal with you?
Yes,
Do you have a copy of that?
SLP. And the SLP, my lord, what happened, my lord? We have stated in our petition also. But while he was in jail, my lord, he engaged some counsel, my lord. He filed an SLP, my lord. And my lord, since it was given to other counsel, the entire record was written. And nothing. And if your lordship, my lord, seek, my lord, I can get a certificate copy, my lord.
No, not
And-
required. Not required. Yes. It should happen first. We need first. We discuss. Then you cannot say that this is a written statement. Because then page 8. Make it page 94, sir, 93. How far is this review petition? Next page. Next page. Then it says This. It is a player. This is a player. Some additional documents. This is this player. Next page. This is. Yes. Each one of these. This. Seva. So, as per the court, this monkey. So. And in the. Breaking must be. This one is. Sleeping. This must be done with. Cannot be controlled. This is the pending. This is one of these contributors. Next benefit. It's a repetition. It takes a new problem.
My lord, on the point of the
This block is. Paragraph 6. Is the statement. And no one is passed. It's due to rejection. The entry is passed positive or is passed. The prayer is due to be have been rejected. Is the plan. Is it? Rejected. Now even if they not passed to you. You need to be rejected. That is a good one. Was it? Ask this. Okay. Okay, we close it with pass orders.
Go for it. Go for it. Go for it.
Technical submission to give.
The-
My lord, should I submit some more, my lord?
Yes, yes, why not?
Actually, what happened, my lord? In this case, the trouble started, my lord, when the notice has been issued to the petitioner, my lord. And for a moment, my lord, may I draw your lordship, page number 79, my lord.
No, no. We told you we are somehow versed with what has happened. You see, you wanted to hear from us. You initially filed a written statement. You did not say the name of your father except in the verification.
My lord.
Then the opinion was rendered saying that the documents you are connecting to for your father, it was Abdul Razak or something, names I
Yes,
forget.
yes.
My lord,
Names I
correct,
will not remember.
correct,
So, Abdul so and so is your father. That was, it does not connect you to the Kamaluddin,
Yeah.
which is your father.
Yes.
Then you file a review petition. In the review petition, you take a plea that please allow me to file an additional written statement and documents.
Right.
That was rejected,
my lord,
not accepting your version that you are the son of Abdul
my lord,
so and so.
correct, my lord,
Then you come to the High Court.
my lord,
In the High Court, you challenge both the orders.
my lord,
And at that point of time, what this court did was to call for the authorities in the SEBA, and they did a checkup, and on the original records, you were found to be the son of Kamaluddin.
my lord.
The court
No,
arrived
my
at a
Qasim
finding. Names I said, I excused, seek your excuse for names, jumbling up of names. I'm growing old. So excuse me for that, jumbling up of names.
My lord,
Now, in the High Court, when this investigation was done, it
Right.
was found out that when the certificate was issued to you,
my lord,
inadvertently it did not contain the name of your father.
my lord,
And therefore, in a different handwriting, the name of this Abdul so-and-so was
Right.
written.
my lord, correct,
What transpired in the court, we will not, I was not there, I may not know, my brother doesn't remember it.
my lord,
After 2018,
my lord,
we don't remember what has happened. But then the court went into merit and then dismissed it.
my lord,
We wanted to know from you as to whether you have a copy of the SLP, just to see what plea you had taken. But when we said we don't need that, there's a reason for it, because now in your written this review petition,
my lord,
in paragraph M, you have said that your father's name is Kamaluddin alias so and so. Both names are interchangeably used. And you also say that in some documents, my father's name is so and so. And in this some documents, your father's name is so and so.
my lord,
The matter ends there.
my lord.
We have missed out anything? Have we missed out anything?
My lord, only thing is, my lord, in the notice, my lord, Kamaluddin is there.
No, whatever it. But now you have admitted it.
My lord, my lord, there are three names, my lord. Here, my lord, the confusion has arisen. My lord, I am admitting, my lord, same. Confusion has arisen, my lord, the notice has been sent under the name of
No,
father's
you
name is
can't say that. We'll tell you why confusion doesn't arise here. Number one,
You are yourself
No, right,
a
your
Bachelor
lord,
of Science.
Yes,
You are a Bachelor of Science.
my lord,
You withheld your educational documents,
my lord.
correct? Then you take a plea in your review petition that your lawyer did not know anything about it. Writ petition or, I think writ petition or review, I forgot.
My
You
lord.
take a plea that your lawyer did not take care, did not take instructions and made a wrong representation.
Yeah, otherwise.
desperate?
Hmm. Here, my lord, before accepting the brief, my lord, I had a consultation with the client, my lord, and admittedly, my lord, some mistake was committed by him. So far, my lord, the admit card is concerned, my lord. Admit card is concerned, my lord. My lord, that was, my lord. He said, my lord, at that stage when this has come, I am repeatedly refusing that I am not the son of the Kamaluddin, and it was, and I have submitted all the documents before the tribunal in the name of the Abdul Razak, his father's, my lord. And all those documents were not accepted. And thereafter, my lord, he has also become frustrated. Out of frustration, I do admit, my lord, that was done. That was, my lord, the forgery part, my lord, by NSC, the name, my lord, that was done by
Can you
him.
say anything
And
since
for
the bench taking up the writ petition did not make any comment. We also reserve our comments. We don't make any comment. What has happened if the bench taking up the writ petition has condoned it? We are not raising that issues.
my lord,
We'll taking note of it, we'll consider. The submissions of Mr. M.H. Chaudhary, the senior counsel, assisted by
MK Chaudhary.
Mr.
MK Chaudhary.
M.K. Chaudhary, counsel for the petitioner, as well as Mr. J. Pang, the standing counsel for the FT matters is concluded. So and so appears for all of the respondents. Order is out. We are keeping it this way as per the timing.
Hello.
Please remember, and when we release the orders, please remember and collect it back.
Item 2.
We wait for some time. We got item 3, then. Oh, they reviewed. Is there reviewed?
That's why it is a vote.
Yes, item 3.
May please, Your Worship. My lord, the IA is for a condonation of delay of 2,417 days also.
What is your explanation?
Worship, I have explained, paragraph 2 is my explanation. I have admitted that I am aware of the order, but reason I have stated why I could not file the petition also.
Please tell us what is the error in the order? What is the error in the order which you are highlighting?
Lordship may kindly come to the order. Order is at page 62.
Page
62. Page 62 is the order.
yes.
My lord, in this case, the notice was not properly served, Lordship. And notice is not at par with the provisions of order 3 of Foreigners Tribunal Order 1964. And notice, Lordship, I have annexed at page 105. Lordship may kindly see the notice.
Please come to page 15.
15, Lordship.
Yes. Where is the ground in the writ petition that notices were improper?
But Lordship, I had a statement in my written statement, page 50.
Hmm?
I had a statement in my written statement, page 50, regarding.
Written statement, you only say that it was not proper. You don't say anything more.
Yes,
You,
Lordship.
you merely say in your, that proper inquiry was not made.
Yes. That was not aberrament in my petition, Lordship. And the Lordship, another ground, Lordship, the evidence was not at all discussed, Lordship. And the DW was not cross-examined. While the impugn order was passed by the learned tribunal,
Mr.
Lordship,
Mr. Hussain,
Lordship,
regarding notice, what do you mean notice was not properly served?
while serving notice, there
Ah.
has to be grounds of doubt, main grounds.
Grounds of
Lordship-
doubt?
Lordship, may kindly come to
No, that's okay. Now come to page 9 of your review. Where have you taken that ground? My brother has pointed out the writ petition, you have not been able to show. And even in this review petition, you have not taken such ground. So from where you're making that submission?
page 11, Roman 6, Lordship.
Okay, this was taken in the writ petition also?
Mm.
This ground?
Regarding this, there is no aberrament in petition. Lordship, regarding the discussion of evidence and cross-examination, I have stated in ground number 5, Lordship, Roman 5, page 10.
These grounds relate to erroneous decision. Where is a case of review? You said that you led evidence, this was not considered.
Yes.
It would be a wrong decision. We fail to appreciate certain facts. It's a wrong decision. We did not consider any document, that's a wrong decision. We did not mention about the evidence of DW1. It's a wrong decision. But where is a error apparent on the face of record?
You check the order was passed under Article 226 of the Constitution of India.
Pardon me?
Under Article 226,
Yes,
the case was decided, Lordship. And as your Lordship knows, the scope of 226 is very wide, Lordship. And all these things covers the comes under the purview of 226, Lordship.
according to you, under 226, what is the specific jurisdiction we are exercising? We have 5 classes of writ petition:
Lordship.
mandamus, habeas corpus, certiorari, quo warranto, and
Habeas
what is
corpus.
it? Huh?
Habeas corpus.
Warranto,
Certiorari,
certiorari,
mandamus, prohibition.
prohibition. So in these 5 scores, which is the jurisdiction we are entertaining here?
Otherwise, Lordship, the order passed by the learned tribunal says that the petitioner could not establish link, Lordship. Lordship, apparently there are some mistakes in conducting the case before the learned tribunal. If your Lordship comes to page 70, Lordship,
Page
for a moment, Lordship, 70.
70.
Yes. 70.
Yes.
Sikim Ali and Rubjan Nesan, parents of the petitioner. And the father's name and mother's name, parents' name appear in the voter list of 1960, 1970. But what has done before the tribunal, while executing these documents, they obtain only the name of the petitioner. Whereas the parents' name appear along with the petitioner till 1993. Those documents were not exhibited before the learned tribunal. They brought only a single name document, Lordship.
Okay, just. tell me,
Therefore, there is failure
what
of
is what is
link,
the
Lordship.
first, which is the first voter list where your name appeared?
Lordship. '85, Lordship.
85.
85 voter list, page 33.
85, you are 34 years old then.
Yes, Lordship.
34, 21 is the age 13. You go back 13.
Sorry, Lordship, page 70, voter list of 77, page 68. Page 68.
8.
Yes, Lordship.
'68. Your name is?
I am
Nathan
Lordship,
Ali.
Nalsan Ali, the serial number 16. And above two names, 14 and 15, parents of the
This is
petitioner.
an exhibited document. I don't
No,
remember.
this was not exhibit, these documents were not,
Ah.
that is what I am
No,
submitting.
we are asking you from the exhibited documents.
Exhibited documents were only single name document, Lordship. Lordship may kindly find page 33, 85 voter list.
Age?
Page 33, 85. Only the petitioner and his wife. Whereas his parents' name appear beyond 1993.
But that would. Mr. Hussain, I'm sorry, we are unable to communicate it to you. You see, we are trying to find out the error in our orders. We are exercising review jurisdiction. What not we have, we are not examining right now as to what documents were left out for consideration. Because in the writ petition, you never projected that please come again if I am wrong, page 15 onwards, in the writ petition,
Yes,
it is not your case that despite due diligence, this could not be exhibited. Please, there we have missed it.
those governments are not there in the writ petition. Those are
In
missing.
a review, it will be very difficult.
My humble prayer is that, Lordship, if a chance is given, he can, otherwise I have to refer your Lordship to those documents. Well established linkage, Lordship. They can establish linkage. As a question of citizenship, Lordship. Lordship will kindly consider that part, Lordship. Otherwise, I have all documents, I have referred to your Lordship.
Well, my argument would be, first of all, my lord, the delay condonation petition may not be considered on this ground itself, my lord. Because though it is stated, my lord, due to poor economic condition, he left Assam and worked somewhere. And for that reason, my lord, he could not file this review petition in time. The 2,370 days delay. This is not a good ground for my lord review, my lord, condoning the delay. That is my first submission, and that's why, my lord, this review petition may be dismissed on this ground itself, on delay in access. This is not supported by any document, my lord. The para 2 of the IMN. Simple statement that due to this poor economic condition, my lord, he left Assam. In fact, if I may say, my lord, he's evading the arrest, he's evading the entire process for last 5-6 years by leaving Assam, staying in Kerala. Now, when, my lord, as your lordship knows, my lord, the entire India is now certain, my lord, is taking up steps to detect and deport these foreigners. They're now coming away from those places and now filing this review petition. Otherwise, they would not have come before this honorable court. And this is not supported by any, my lord, the document that he was working somewhere and he left the place informing the, my lord, authority. In fact, it is the duty, my lord, as per the law. It was their duty to inform. A declared foreigner, in fact, should not have, my lord, cannot, my lord, leave where she was originally reside. If she is living somewhere, she has to inform the authority. Giving goodbye all these things, my lord, he has evaded. Now coming back after 5-6 years, they're coming with a plea that due to, my lord, poor condition, economic condition, I could not file the review petition at that time because declaration was finalized in 2018 itself. Now only because they're coming in 2025, the other states of this India also, they're taking steps to detect and deport these foreigners, my lord. They're coming with this kind of plea. So my first submission will be, my lord, this review petition will be dismissed on this ground itself, delay in lapses. Secondly, my lord, if I go on merit, my lord, the review petition is, as your lordship, my lord, knows, I'm not, in fact, I'm submitting always. Review petition is not an appeal in this case. What my learned friend is arguing, my lord, arguing the same writ petition. My lord, that these documents, this fact, this, in fact, this honorable court should not have, my lord, appreciate the documents and evidence under certiorari jurisdiction of 226. This honorable court was only to see whether there is error, my lord, jurisdiction of error, or whether there was, my lord, the violation of any principle of natural justice in the tribunal. If that is not, this tribunal could not have, my lord, thus the facts of the case. My lord, now my learned friend is, my lord, filing this review petition saying that this honorable court has not appreciated this fact, failed to appreciate this, my lord, evidence. This honorable court should not have, actually. It is not necessary by this honorable court that all these facts has to be appreciated. This honorable court under certiorari, my lord, only to see whether the tribunal has gone beyond jurisdiction, whether tribunal has not given him or enough opportunity or not, whether there is any violation of principle of nature. That must only. And that's why this honorable court has rightly passed this order. If he is not satisfied, my lord, yes, obviously they can approach the Honorable Apex Court by filing an appeal. But this is not a jurisdiction matter. This is not a case for review, my submission. My lord, to that effect, my lord, my learned friend was asking, actually, I just point out para 112 of the, my lord, this Muslim mother. It has entrusted, my lord, this honorable court what to do, what this honorable court can do under 226 certiorari, my lord, in case of foreigners cases. because we don't have, my lord, rules or sets of rules. This honorable court has time and again, my lord, passing some orders on the basis of which this, my lord, we are functioning in fact. The para 112 has said, my lord, only 2-3 lines. Article 226 of the Constitution confers on the High Court power to issue appropriate writ to any person or authority within its territorial jurisdiction. Now, my lord, the tribunal constituted under the 1946 Act, read with 1964 orders, as noticed above, is required to discharge the quasi-judicial function. This is the function of the tribunal, man. Now, the High Court therefore has the power under Article 226 Constitution to issue writ of certiorari. What right writ, man? Issue writ of certiorari, quashing the decision of the tribunal in appropriate case. So under this authority, my lord, this honorable court is functioning. And what is the jurisdiction of certiorari jurisdiction? That is also given here in the same paragraph. Certiorari, my lord, there are numerous of judgments of this honorable court, honorable apex court. What is the authority during under certiorari? That I'm not going to elaborate all those things. This is, in fact, this has been, my lord, cited again and again, my lord. This certiorari power, 2023 S11 SCR 731, my lord. This is Central Council of Research in Ayurvedic Science and versus Bickerton Das and others. In this case, my lord, from para 50 onwards, the principle of certiorari jurisdiction has been detailed discussed. After analyzing the judgment of Honorable Apex Court of last 15 to 60 years, my lord, this has been, a guideline has been set out. To grounds, whatever taken my line by my. In fact, the, my lord, Honorable Apex Court has depreciated, my lord, the changing of counsels for filing review and, my lord, review juris cases, my lord, while after retiring the, my lord, the honorable judges. And that has been depreciated by Honorable Apex Court in numbers of cases recently, in fact, imposing cost, my lord. One of such cases, my lord, this was in 1997. This honorable court also, my lord, numbers of cases dealt with that, my lord. Yes, this is one judgment, my lord. I can submit another judgment also. This is 1997, 9 SCC, my lord, 736.
Mr. Payang, what is this regarding?
Judgment, my lord.
Regarding.
Changing of counsel.
Regarding filing of, my lord, review by changing advocates.
Okay.
Because, my lord, the original advocate, he have filed the original writ petition with some points, my lord, some, he placed some facts and some arguments, my lord.
Mhm.
This is sensed by changing the advocates, my lord.
What is the relevant para?
Para 2, 3, my lord. In fact, only 3 paras are there, 1, 2, 3.
Okay.
After changing even judgment, my lord, after 5, 6 years, they are filing cases. 736, my lord. 36, my lord. Tamil Nadu Electricity Board and others, another. There are other judgments also. I could not find it now, my lord. I can provide. This is available as on now with me. This is, in fact, in case of review. In fact, 2 latest judgment was also there, my lord. No, petition, 80. I have found the another one, my lord. There's another judgment on this point, my lord, your lordship. That is judgment 2021 7 SCC 206. Let me listen. 2021 7 SCC 206. It is short.
On the same point.
Same point, man. Review. In fact, their delay and let's say is also taken consideration. This is after retirement of the learned Madam Honorable Judges, the filing of review.
Oh, that case.
Yes,
3 judges bench.
yes, 3 judgments. No, this is division bench. Honorable Justice D.Y. Chandrasuri and M.R. Shah.
Okay, may I add few lines, Lordship? Regarding, Lordship, delay, I am relying on judgment passed by the Honorable Supreme Court.
Is it reported?
Before report, it was printed, Lordship, reportable, written as reportable.
Reportable.
It's Lordship, may kindly see paragraph 46,
46.
46, page 35. 46, 47, 48, 49, 50. Improvement. Okay. My learned friend has referred to paragraph 112 of Muslim Mandal judgment, Lordship. Lordship. Paragraph 57. Lordship, those relevant paragraphs I have not gone. Yes, sir.
And before the. So effectively, the political taken. The. And population. The. Political planning. Therefore. So there was a 20-year old day. And let's take it. Otherwise, let me tell you. Someday. Kind of fixed and that I can.
Fifty-two.
The environment under this act. Giving by even method of fire.
Paragraph 46.
Figure and activity.
And in paragraph 112 of Muslim Mandal judgment, regarding jurisdiction of writ of certiorari, it speaks about some exceptions also, Lordship, in the same paragraph. Yeah. There is, however, an exception to the said general proposition inasmuch as the writ of certiorari can be issued and the decision of a tribunal on a finding of fact can be interfered with if in recording such a finding the tribunal has acted on evidence which is legally inadmissible or has refused to admit admissible evidence, or if the finding is not supported by any evidence at all. Lordship, in this case, admittedly, Lordship, evidence was adduced, Lordship, but the evidence has not been discussed, and he has also not been cross-examined, Lordship. Is there, Lordship?
I have not got an answer. That's why I'm asking it again. What happens if a suit is filed or a writ petition is filed and without issuance of notice or in the suit, even after notice when the defendant does not appear and the suit is dismissed, then what happens? A writ petition is filed, it is dismissed in limine. No notice issued, no returns asked. Or in a suit, an ex parte decision, ex parte suit, there also the suit is dismissed. Then what would you say? Will that judgment be expressly wrong just because the defendant was not there?
In this case, Lordship, admittedly, the petitioner is an illiterate person, as your Lordship knows. And the conduct of the case is the domain of a learned counsel, Lordship. And as it is seen in this case, the case is
But
not
that we can't
conducted
help.
properly, Lordship. It is
That
to
we
be
can't
looked
help.
into by the council, Lordship.
You see, we will be very happy. We'll tell you, both of us will be very happy. Give me an instance where I can say that I have heard a counsel and I don't use the word learned. If I am permitted to do so, I will definitely omit writing of learned before many counsel. You can just give me one handle. We'll be very happy. But till the day we have to respect the bar and say that we have heard learned counsel, we can't help it. We can't say he's not learned. We can't say he's ill-equipped. We can't say that he has not had proper training. We can't say that he is not versed in law. Although we feel like it at times, it can't be helped. Unless, of course, you can, it is within your domain to write to the Bar Council so that there must be periodical training of every lawyer. Once an idea was mooted, there was strike all throughout the country. But in a charter accountants, every year they have to mandatorily do some hours of training. Otherwise, their licenses don't get renewed. If you just walk out and then talk to any charter accountant, he will tell you that he is versed with the accounting principles of, I think, 16 or 17, which is now prevailing. If you can have the Bar Council done, do up the training program, then we'll see. You may not like what I'm saying, but that is the hard fact. If you don't upgrade the lawyering skill, people will not know about it. And you know why why I'm repeating it. Yesterday also I repeated, today also I'm doing it. You know why? I can tell you 95% of the lawyers who are appearing in this bench for foreigners tribunal cases, they don't have the time to look at the LCR and then address us. Without knowing the trial court record, will anybody succeed in a foreigners tribunal cases? But no, everybody is learned. We are the only ones who have solemn duty to read and pass judgments. Advocates do not take a plea, what you call a pledge that I will discharge my duty in accordance with law. Yesterday in an interaction, we had Mr. Mazumdar. No, don't stand up. Mr. Mazumdar was there. I was telling him. You see, in the lawyering upgrading skills, about a year back, Mr. B.B. Todi, the senior counsel, Dr. B.B. Todi had done it. 90 lawyers were there. Nobody wants to upgrade their skills. So please don't blame the lawyers. They have a tag of learned with them, and we respect them for that. 80% of our work, it becomes easy. Mr. Ayuddin is here. You know, don't stand up. You know, he argued a criminal matter and we acquitted. And we had to regard him for his able assistance to us. And that he could do only when he was well versed with the trial court records. How many days hearing, Mr. Udin? 5 days. 6 days. Almost half day hearing every day, correct?
Yeah.
We have to appreciate. If we done the hard work, we are there to appreciate. But once you say a general statement that the lawyer did not do it, I find it very difficult. Okay, submissions of Mr. M.I. Hussain, learned counsel for the petitioner, and Mr. J. Pang, standing counsel for the FT matters is concluded. So for the respondents are present. It is up for judgment.
Thank you. Item number 2 was fixed for the timing problem.
Yes. That was the lawyer come.
I don't,
Item 2.
no, I've not seen him.
Say the item 2. On the second call, the learned counsel for the petitioner is absent. The all the respondents are represented. The default continues on the next date of listing. Adverse orders. This has been when the next step.
Item number 2 and 3, my lord. There are certain developments, my lord. In the meantime, the cadre strength has increased. Then there is amendment of the rules. So, my lord, it will have some bearing on the case. May I pray for a 2-3 days time, my lord? I'd like to file an additional affidavit bringing on record those aspects. Two and three, my lord.
2 and 3.
Yes.
Your
Item
lordship, may I just
23.
say, I am appearing for the private respondent in this case. Although there is some amendment of rules, as my respected senior is saying, it will not have any bearing because the challenge is made on the basis of the rules exist at that moment of time, your lordship. So this
my
will have
lord,
no,
No, my lord, to the
No,
promotion to the grade of engineer will
Because
be
you
held
see,
now.
If what Mr. Chaudhary says is correct.
Yes.
i-
There's
if he may
increase
be,
in cadre strength also.
if he
Earlier the
may be
executive
adjusted,
is 8, now it is 18.
your
may
lordship,
be adjusted,
Yes,
he will perhaps be
yes,
satisfied.
yes.
your lordship, the entire promotion was carried out in violation of the statutory law. And the Supreme Court, as well as this honorable court, has categorically stated that the conditions of recruitment cannot be relaxed. And it was given a go by your lordship. Neither the relaxation nor the repeals and saving causes helps them, your lordship.
No, this will come when we admit it. This is for admission.
Your lordship,
stage,
item number
that
three,
matter-
item number 3 was heard at length. May I just submit, your lordship? It is up to your lordship at the end of the day. The other matter was heard in length, your lordship. I don't mind they taking time or bringing something, but that they has been doing since long, your lordship, bringing in piecemeal, your lordship. But anyway, let it come up on Wednesday, your lordship. Otherwise, the other matter has been heard. In fact,
Yes, yes, let it come upon Wednesday.
Wednesday will file no. Volume niya. Volume niya.
Yeah, fine with that.
Item 20. All sides are represented. Mr. K.N. Chaudhary, learned senior counsel, assisted by Mr. S.K. Das, learned counsel for the appellants, has submitted that in view of certain developments which has taken place,
Next witness.
he is awaiting further instructions, and therefore he
Let's
placed
file an additional affidavit, my lord.
instruction and to file an additional affidavit, so advised. And accordingly placed for adjournment. Next, Mr. R. Sinha and counsel for respondent number 7 opposes the chair for adjournment. Be there as it may. In view of the prayer made, leave to file additional affidavit by the appellants is allowed. List on
10, my lord.
10,
Yes.
8, 25. 10, 9, 10.
10, your lordship, and they'll file the affidavit by 8, your lordship. So that
File by Monday. Or Tuesday.
Monday করি তো 15 পাই যাম।
Okay.
To read once, Mr. Chaudhary says.
Deep down.
May I please, your lordship? My lord, I beg to mention, my lord, item number 4, my lord. My lord, what has happened, my lord, the council who is holding the brief, my lord, is on dialysis, my lord. Some medical emergency is there, so my lord, may I pray? Lord, matter may be taken up on Monday or Tuesday, my lord.
So it's good after a week. Also, as I represented on the prayer made by Mr. Ayer, this Mr. Ayer, we and counsel of the petitioner has submitted that the learned counsel holding the brief is indisposed. So accordingly, matters stand adjourned today. List on 15/9/2025.
My lord. Oblige.
Your lordship, I beg to mention item number 5, your lordship.
It
Probably,
will not be by this bench.
probably not by this one.
5 and 6. This is the matter before any other bench without one of us. I'm Sundar J. Okay. Yes.
Oblige.
May I please, your lordship? My lord, in respect of item number 13, I have filed an adjournment request.
13 years.
Yes, lordship.
In item 13 and 7, there is a adjournment slip.
Come after the vacation, lordship.
Says a representative. Item 6, sorry, 7 and 13. Prayer for adjournment, list after 2 weeks. Okay.
May I
Date
please
of-
do lordships?
2017.
Yesterday we made a
Give a date.
mention.
Give a date. 2017 matter. Yes.
Lordship, yesterday we made a mention wrongly in respect of item 7. We are no longer counsel for this petitioner.
Let's see, item 7. David? David? Yeah, yeah, Item 6, you write.
7.
No, this is item 7. Right. Your name?
Kedas,
You are appearing on behalf of?
S.A. Ahmed.
No. No. Your name is?
Kedas.
Look what you have written here. You have taken consent of Ms. Verma. You did not make a mention that you are not in the case. No, we understand. No, we understand. Look at your slip. Look at your slip. Show it to her.
You're senior, I think. I don't know, somebody came. And Lordship, if it's a 17-16 matter, refused to sign.
Look at your slip.
This is, who's S.A. Ahmed?
My senior.
S.A. Ahmed had taken it from me. Her senior, Mr. S.A. Ahmed, he had come to me.
We understand.
Yes.
That's why you see, Ms. Das, please understand. I have no other business, therefore even adjournment slip I read. Nothing is per chance. In the adjournment slip, you say that the counsel is out because of medical emergency. And now you are making a submission that he is no longer there. We take very serious note of it.
Chip, I would just want to say, maybe she's been instructed like this.
No,
by her
whatever
senior doctor.
we are not, you see, we are not.
Juniors will
we
come
are
and
not-
say what the seniors teach them.
No, we
Lordship.
understand, but we are not writing in the order. But I am cautioning her that if it is in this bench, I even read this adjournment slips. So
Are you understanding what is being told?
it has implications. You see, many things we accept the stand of the lawyers and we don't ask questions because we respect all of you. So don't let us lose faith on the system where for every statement of every counsel, we will have a doubt. That statement of yours rekindle our memory to this adjournment slip. You made us read the records. We found out 2 wakalatnama there on record. And this is how we have examined it. Nothing is per chance. Correct. We don't record it because otherwise we'll be harsh. Just we are adjourning it.
Nothing, Lordship.
Yes.
Can you accommodate, my lord, item number 10 and 11, my lord?
No, without an adjournment, we are not adjourning.
This is my,
You
from
just-
from last night, I am suffering from headache, my lord. That is why, my
It's
lord.
okay. You just pray that we may not reach there.
I am here, my lord. I will be here. But
But
the problem is that I am suffering from the last night, my lord. That
except
is
for
why.
some good deed of praying, we are not intend to adjourn.
But
Daily list item 1 for admission.
Yes.
But the detainee was first arrested on 2/1/2024 in connection with NCB case number 17/23. And on subsequently on the next day on 3/1/24, he was shown arrest in connection with the NCB case number 18/23. Now, in both the cases, from the detention order, it is found that he is the receiver of in both the cases of the drug, which was seized from the other persons. And in both the cases, commercial quantity, and also that he has transferred money 3 times to a person who was caught with from whom the drugs were seized. So he has transferred money to the tune of rupees 1,20,000 something. Now, when he was in jail, first bail petition was moved, which was at the time 1019 in connection with NCB PS case number 17/23. It was closed as charge sheet already submitted on 2/5. Both the cases were bail petition was closed on 2/5/24. Now at that day, Counsel has stated that it was stated as disposed of, asking them to appear before giving a chance to appear before the trial court.
2/5/24.
2/5/24, yes. First, in connection, BA 1019/24, in connection with NCB case number 17/23, and BA 1014/24, in connection with NCB case number 18/23. Both the cases were disposed of on 2/5/24, giving a chance to appear before the trial court as already submitted.
Case based bill number, BA number?
BA number 1019/2024.
Second one.
1014/2024.
Okay.
On the same day, my lord. That is 2/5/24. And that day one submission was that from the council, my lord, that it was we have in the mention in the detention order as dismissed. Actually, my lord, bail, that is the understanding of the authority, my lord, bail was not granted actually. Bail was not granted as because such is submitted giving opportunity, it is closed. As bail was not granted, maybe they have interpreted as the it was dismissed. Otherwise, my lord, they have filed subsequent bail petition, 2 bail petition again, BA number 1205/25, in connection with that NCB case number 17/23, and BA number 1364/25, in connection with 18/25, 23.
What the numbers?
Well, first BA is 1205/25, in connection with that NCB case number 17, and 1364/25, in connection with NCB case number 18/23. Now, in both these petitions, they have challenged actually on the ground of providing the grounds of arrest. That in the technical ground. And detention in the meantime, the authority as the NCB has given the proposal, authority has worked on it, and the detention order was issued on 13/5/2025. Subsequently, on the next day, 13/5, it was issued, New Delhi, Malay. On the next day, first bail petition 1205 was disposed of, allowed on 14/5/2025 on the ground of non-furnishing of the grounds of arrest in the notice. So only on the technical ground. Now,
In both cases.
both cases. Second case was disposed of on 28/5/2025. 1364/25 in connection with NCB case number 18/23. It was disposed of on 28/5/2025. In the meantime, my lord. But at the time of issuance of the detention order, 13/5/2025, both these bail petitions are pending. Both the bail petitions are pending. Now, one questions arise, Malad, in other cases also, Malad, when there is a bail petition regarding to commercial quantity of NDPS, Section 37 embargo is there. Why necessary to pass such Malad or detention order? He is already in custody and embargo of Section 37 is there. Malad, regarding to that, Malad, in the detention order itself, authority has mentioned that time and again he has filed bail petitions, and they have put the ground that ground is it was not received, not seized from his custody, Malad. Drugs were not seized from his custody. And then that ground, and time and again they have filed a bail petition. But it is also, Malad, in the record that the second bail petitions, two bail petitions they have filed on the grounds of non-furnishing of grounds of arrest. So which is in record, Malad, and if that is available as per these Supreme Court directions, Malad, beyond command, etc. So there is every possibility to release them on bail, but not on merit. There is every possibility to release them on bail, not on merit, but maybe release on bail because of this technical ground. And ultimately that order has been issued on 13/5. Now, during this pendency of the second bail petition, because Malad, second bail petition, Malad, that is BA number 1364/25, that was disposal on 28/5/25. Before that, when the query was asked, and perhaps Malad, I have not gone through, but because it is reflected in the order 28/5, that already a detention order has been passed and it was shown to the court. So in my affidavit also I have mentioned that authority has not suppressed anything. Detention order has been passed on 13/5. But regarding communication, I am passing of a detention order and to execution, Malad. Malad, in that moment, Malad, I am pausing and Malad, I am come to the PIT NDPS Act, Malad. PIT NDPS Act, Section 4. That is execution.
NDPS Act. NDPS.
PIT NDPS Act, Malad. PIT NDPS, Malad.
It is in that book.
It is in the NDPS book itself.
Yes, sir.
It is.
Section 4.
NDPS Act to video তাতে থাকে।
Otherwise, only two lines, just Malad, I am reading, Malad.
No, if I don't read, I won't remember.
Malad.
But we have an extra book here. Please.
मैंने क्या दिया?
जेनुका से इनको देखिए। 870.
Section 4 of the Act, my lord. এখন আছে নতুন।
আরো এটা আছে।
My lord, Section 4 regarding the execution of the detention orders. My lord. A detention order may be executed at any place in India in the manner of provided for the execution of the warrants or arrest under the Code of Criminal Procedure. My lord, I am showing this, my lord, because there is no such time limit that it should be executed within 5 days, within 7 days, within 10 days. And now, along with at the time of execution, within 5 days, maximum 5 days period, my lord, we have to submit the grounds of arrest, all relied upon documents, all have to be given. And also, as per the Bayan Kumar judgment, we have to given in translated copy also. In the meantime, my lord, 13.5 order has been passed, it is communicated to the authority. And in the meantime, 60 pages document has been translated in Assamese. And it was executed on 28/5. And on the date, same date, at the time of execution, all documents, grounds of arrest, and all relied upon document has been given to him, my lord, on 28/5, with an Assamese translated copy. Now, this 15 days time required, my lord, orders passed in Delhi, my lord, it has to come and subsequent to translate 60 pages. Now, one argument has been made. That
No, but you see, this doesn't take us anywhere.
No, no, my lord,
Because, for example, if you make me, let us assume that you give it to me for translation. Even one page with the work amount I am doing, maybe one page of translation will take me 10 days. If you give it to Mr. Mazumdar, he will take 20 days. He doesn't have time for this.
my lord, I am saying, my lord,
But
no,
it can't
no,
be helped.
it should be, my lord, legitimately, no,
It can't
my
be
lord,
helped.
negligence, my lord, on the part of the authority, my
No,
lord.
negligence is not an issue in the what do you call this?
And my lord,
Preventive detention cases.
my lord,
Nobody is making assessment of the issue of delay and latches.
my lord. Delay, my lord, if at all, my lord, after execution within 5 days or we have not supplied the documents, that is a remarkable delay. First of all, my lord. And now,
Because
in the-
once there is a delay,
at the time of the bail petition, my lord,
if there is only one default, which is the delay in service, that itself leads to quashing. You don't have to do any hearing.
my lord. And one thing, my lord, that day, my lord.
Any judgment in the country by any constitutional court saying that the time spent for translation for service is a valid excuse. Any
But
constitutional
regarding delay, regarding representations, dispose of that delay, I found, my lord, but regarding execution, my lord, 15 days delay, my lord, I may be wrong, my lord, I have not found, my lord. Regarding
Then-
execution, my lord.
No. Then perhaps you did not hear when Mr. Biswas was citing. He cited cases that 7 days delay is fatal.
Amina Begum, my lord.
Oh, whatever be, I don't remember. I have a very weak memory. But he made submissions where one case 7 days, one case 8 days, one
Those
case
were,
15 days.
those were, my lord, representation regarding.
No.
And-
Service of the sending of the representation and the what you call disposal of the representation.
Yes, my lord. But here, my lord, that delay.
Oh, he gave a citation. First citation was that only. What was that case you gave us? Delay in
Execution.
service of the detention order.
Service of the detention order. My lord, my judgment, the judgment which I relayed is the time they have consumed, 5 months time from the date when the sponsoring authority sent the proposal to the detaining authority and the detaining authority issued the detention order
after 5 long months. So on that, there is a judgment exactly 5 months past. That is, that judgment is
Which was that?
2022 SCC Online Supreme Court 1333.
But on the last occasion, your lordship asked me to furnish this
List of cases with paragraph numbers. My lord, this is what I am furnishing. This will suffice, my lord, because here even I have given on what point which cases are being relied on. And all the
Give a copy to.
copy, the other day I have given him. বুটে টু দিয়ে দিছে এটা এখন রিটেন আর্গুমেন্টেড বুটে টু দিয়ে না জানেন এটা এখন একবার দিছু বলা
দেখাইছিলে মই লোৱা নাই।
Okay, we'll continue to your book.
Add to my lord.
Please give him that book.
This detention order, it does not say that on the subsequent filing of the bail, you have taken up this loan. So
My lord, it is
that is
mentioned
an
that
explanation.
time and again filing of that is mentioned.
That was done in March, it was over. And you have only referred to that March part only, that it was rejected. Thereafter, the other second
no.
bail petition and all that, those are not even acknowledged anywhere that there
No,
was any
It
information.
has been mentioned that time and again. My lord, in the detention order, my lord, page 4. It is in page.
That part we have seen.
Yes, my lord.
I am aware that at present you are in judicial custody. However, considering your so and so, I am also aware that in both the cases you are seeking bail time and again.
Time and again.
But that time and again, only one instance you have given paragraph M and all that. And you never went for cancellation of bail. No attempt to get it cancelled or anything.
No. Because both the bail petitions were allowed, not on the merit, purely on the basis of technicality.
How does it matter?
On technical part, otherwise materials are there. Both on the grounds of arrest, they have annexed the bail petition orders. Both the orders have been annexed by.
Was it contested by you that no, this technical should not be released, even apart from it may have been rejected or allowed, but was this an attempt made to resist it?
Yes, my lord, that is there. That is there in the order. Sufficient grounds has been mentioned. Page 25 of the writ petition. According to the learned council, NCB council, the accused number Yusuf Ali has been organizing illicit trafficking. On that ground. It is reflected in the page 27, para 12. Admittedly, accused number was shown arrested in the other case and no grounds of arrest has been relied. That is on record, my lord.
Anything further?
The school education we got. Perhaps the teachers were wrong when they were teaching us, try again until you succeed. What is that poem? Try again till you succeed. Perhaps the teachers were wrong. Tomorrow the teachers' day is there. You have to raise a protest. Once bail is rejected, second application should not be filed. No try again business. We are saying so because we will save our lot of time and energy on review. Once dismissed, no try again.
There's one story that spider tried to climb up 7 times. That spider story was there.
Ah, yes.
King Robert.
King Robert.
Robert.
He lost the bet.
Okay, we reserve it for others. Submissions.
My lord, only quick. My lord, my friend has relied on this WPC criminal 33/2022. My lord, I am relying on the same judgment para 27. Perhaps para 27. So this judgment, in fact, it helps me. Para 20.
All both sides are represented. The submissions of Mr. K. Parashar, learned at CGC is concluded. Submissions in reply by
123, my lord. For aspect number 123.
submission in reply by the learned counsel for the list is also concluded.
Order. Four. State domain.
Anybody else is there?
Four is state advisory, state advisory.
State, you have anything
Four.
to say?
Formal part.
And that submissions of Mr. S.K. Hazarika and committed for is also concluded.
I'm appearing for responding to number 5.
Number 5. Who is 5?
NCB.
NCB.
Sponsoring authority.
Okay, you have anything to say? Your name?
R. Hussain.
R. Hussain, on behalf of
Mr. Etika.
Mr. S.K. Is concluded. Order reserved.
My lord, only one thing, my lord, in my lead petition, my lord, in the prayer, I have challenged the detention order and all consequential orders, my lord. Because that extension order has come during pendency of the consequential order. And DPO.
Fourth prayer, you are pressing the fourth prayer.
Compensate. Try.
Supply item 19.
May I please report? Lordship, I have prepared the list of the
First 3 pages are your lordship list of death. First 3 pages are list of death. And fourth one page is the timeline leading to disposal of the representation.
One aspect I would like to just point out, the other day at the back end of the argument, when my learned friend was saying that the representation has not been disposed of. Now, I just want to point out one thing before my learned friend starts, my lord. The representation was disposed of on 25/6/2025. So will kindly take up the dates, my lord.
He has made a mention in the list of dates. Page number
No,
3.
not something else I am indicating. It was disposed of 25th of June 2025. Now, in the affidavit filed by the respondent number 4, that is possibly the district magistrate, it was indicated in para 19.
If it will be respondent number 4.
Respondent number 4. In its affidavit, my lord, respondent number 4 has made a statement in para 19, which your
Yes.
lordship will find at page 10, the part I am trying to point out to your lordship.
Yes.
Second line, lordship will kindly see to the best of the knowledge of the deponent, the representation dated 23/5/25 submitted by the petitioner has already been considered and rejected by the authority by an order dated 25/6/2025. So thereafter, the petitioner has filed a rejoinder, my lord, to this affidavit. And in paras 18, they have replied to paragraph 19. This affidavit was filed on 26th of August 2025. Lord, will kindly take and note the dates. Disposal was of 25th of June. Affidavit was filed on 26th of August. And there is a reply.
Yes.
There is a reply in paragraph 18 of this rejoinder, my lord.
Yes.
It says that in response to averments made in para 19 of the affidavit of omission, the deponent begs to state that there is nothing on record to show that the state government has considered the representation of the petitioner. Now, I have supplied the documents with affidavit we couldn't file to bring on record these two documents because yesterday there was a holiday, one state holiday. So we'll see from there, he has received the, my lord, rejection order, second page, my lord, on 3rd of August itself. 3rd or 4th, is mentioned 3rd. 3rd of July.
July.
Any affidavit has been filed in the month of August, end of August, saying that no, it was not, nothing is there.
There is some communication gap between the detainee and.
While the lordships are very strict about the adherence of the strict rules, procedural safeguards under Article 22, and then the provisions of the NSA, what is to be done with this matter? This is a statement on oath by the petitioner, of course. I'm sorry, the deponent. See the manner.
Lordship,
After 1 month, the statement has come.
Let him complete.
Lordship,
Let him complete.
My lord, after 1 month, the affidavit is filed. Everywhere you are raising an objection. Here also there is an objection. It has been raised. Your lordship has asked me, if you have not disposed of the representation, the matter ends on that ground, and around the detention order will go. Now what will happen to this aspect of the matter, ma'am? I leave it to your lordship.
On that, your lordship, my explanation is this, your lordship.
My submission will be, let an explanation come on affidavit to respond to this. I've got nothing against my learned friend, my lord. If he has not been informed, affidavit has been
No,
filed.
that's there, your lordship. I have.
I'm about the
received a
petitioner,
copy.
conduct of the petitioner and the deponent and the detainee.
I have specifically inquired about this, your lordship. So your lordship, there is some communication gap between the detainee and the your lordship, the person who swear the affidavit. He is in jail, your lordship. Therefore, ultimately, your lordship, they skip somehow to provide it.
Question about skipping, well, you're making a statement on oath.
No, your lordship.
Without inquiring, why did you file an affidavit then?
Let me.
This is a high court, my lord.
That's.
Some respect the petitioner, the deponent should have.
I.
He's making a very casual statement on record. Nothing on record to show that the state government has considered the representation of the petitioner. And your lordships, rightly, my lord, pointed out to me that on that ground, the detention order will go. It may go on some other grounds, but this ground, I leave it to your lordship, my lord. So, for me, my lord, it's very serious thing. It is an affidavit on oath before the Honorable High Court.
So far as this point is concerned, your lordship, I can make an explanation by an affidavit, your lordship. In the meanwhile, your lordship, only one thing I will submit, your lordship. That for that, your lordship, there can be, your lordship, the person who has taken the affidavit, sworn this affidavit on oath, some action can be initiated against him if he has deliberately suppressed. But there is nothing I will gain by suppressing it, your lordship. Number one, your lordship, ultimately. Because, your lordship, and the fact remains that, your lordship, the delay that has been committed, your lordship, that has not been explained, your lordship, properly by that will remain, your lordship. Whether, your lordship, that.
No, that's not the point.
Lordship.
The point would be once the additional advocate general is there, and the statement is made, it's not served.
Lord.
It would have gone on that ground. So that would
No,
fall against the state.
That's why, your lordship, I have also on last occasion told that this I will specifically made inquiry with my client. That's why I made inquiry, your lordship, and therefore, your lordship, I have in that list of date, your lordship, and the timeline, I have mentioned that.
Okay.
No. Let me start, your lordship. That point, your lordship, will consider, your lordship. Essentially, your lordship, in from page 5 to 9, your lordship, the grounds that I have taken, your lordship, and the judgments I have relied on. The grounds of silence, before I'm going to the facts, your lordship, to be precise, your lordship, therefore, your lordship, I have prepared this small, your lordship, note on submissions, your lordship. Failure to inform about the right of representing before the detaining authority, that is one ground, your lordship. Secondly, your lordship, that is the delay in disposal of the representation. Then, your lordship, third is delay in informing about the right to represent before the central government, your lordship. Fourth is non-furnishing of relevant materials, your lordship. Fifth is non-consideration of the bail order, your lordship. Six, imposing maximum period of detention without citing any reason, your lordship. And seven, defect in detention order. And number 8 is no live link between materials relied on and the satisfaction of the detaining authority. These are the grounds, your lordship, on which I have put this detention order under killing, your lordship. Now, your lordship may kindly come to page 42, your lordship. That is the FIR, your lordship, in connection with which the detainee was first arrested, your lordship. This FIR, your lordship, relates to his certain statements made by the detainee, your lordship, during the Panchayat elections. And this relates to your lordship, that Prezik Pahalgam incident, your lordship. Allegedly, your lordship, he has claimed that this incident was he has accused central government of, your lordship, orchestrating the Pahalgam effect. This is the genesis of the present detention. Now, in connection with this case, your lordship, the detainee was arrested, your lordship. And when he was arrested, your lordship, on 14/5/2025, his bail prayer was considered by the learned additional session judge. And your lordship will get the order at page 44. May I read the order granting bail, your lordship? Page 42. Page 42.
42, we're there.
44, your lordship. The order granting bail. And relevant part I am relying on is page 45, your lordship. Second paragraph. Your lordship. On perusal of the case that
Yes.
on perusal of the case diary, it is seen that the IO has made no further progress in the investigation since 27/4/2025, and no further entries are available in the case diary. The statements allegedly made were not expected from any responsible citizen, and especially a public representative, at the point of time when there was hostilities going on with the neighboring state over acts of terrorism. Nation and the accused, being a public representative, is expected to be more responsible in his public dealings. Yet, it has to be said that there is nothing to show that the statements may have resulted in any untoward incident. Though the IO claims that phone records of the accused is being investigated upon, there is nothing to suggest that the accused needs to be detained for the purpose of the same. There is nothing to suggest that accused who is sitting MLA will evade the lawful process or make good of his case. Good his escape. Now, your lordship, on the basis of this finding, your lordship, bail was granted, your lordship, and your lordship will find below the conditions under which bail was granted, your lordship. The first condition, the accused person will appear before the IO when called for till the completion of the investigation. The accused person shall not threaten or make any direct or indirect inducement or threat to the witnesses or anyone connected to the case in any form to dissuade him or her from disclosing true facts of the case or tamper with the evidence. Then third and fourth is important, your lordship. The accused person shall not commit any offense of whatever nature in future. There is a condition, your lordship. And the accused will ensure that he makes no statements pertaining to the present case of such nature that may incite violence in any form. These are the two conditions, your lordship, imposed by the learned additional session judge while granting bail. Now, page 47 is the, your lordship, detention order, your lordship will find. It was passed on the same date on which his bail order was granted. May I read it, Your Lord? Page 47. Whereas the report has been received from the Superintendent of Police Nagaon by memo number so and so dated 2/5/2025 along with supporting documents and intelligence inputs indicating that Sri Aminul Islam, MLA Dean, son of so and so district Nagaon has been engaging in activities prejudicial to maintenance of public order and the security of the state. And whereas it has been reported that Sri Aminul Islam delivered a provocative public speech on 23/4/2025 during a Panchayat election campaign at Village Jamuguri, Atina Gaon under the Turia police station, and that a video of his statement alleging government conspiracy in past terrorist attack has circulated widely, resulting in the registration of Nagaon PS case number 347 of 2025 dated 24/4/2025 under relevant provision of law. And whereas I, Narendra Kumar Shah, IAS District Magistrate Nagaon, upon careful examination of the material placed before me, I am satisfied that the said individual is likely to continue engaging in activities prejudicial to the public order and the security of the state. And whereas the government of Assam, in exercise of the powers conferred under Section 3(3) of the National Security Act, has vied notification number HMS top 135/2023/48 dated 14/10/2023. Your Lordship will kindly note this date. 14/10/2023. It is important in view of the subsequent corrigendum they have issued after 1 month. Your Lordship. And under your Lordship, Section 3(3) of the National Security Act, your Lordship, that power, your Lordship, once the notification delegating power to the district magistrate is issued, your Lordship, it normally, your Lordship, remain in force for 3 months. Now, this was dated, your Lordship, 2023. On this date, your Lordship, they have, your Lordship, exercising power under this notification, they have issued this detention order. Now, therefore, in exercise of power so delegated, I do hereby direct Sri Aminul Islam to be detained under Section 3(2) of National Security Act 1980 and be lodged in the Central Jail Nagaon with immediate effect. He further informed that he has a right to make a representation against the detention of its order to the state government or to the advisory board constituted under Section 9 of the National Security Act 1980 in accordance with Section 8(1) of the Act. Your Lordship will find that only 2 authorities, your Lordship, has been referred in this particular detention order, your Lordship, to which I am to submit representation, your Lord. My case here is, your Lordship, is that the detaining authority ought to have, your Lordship, inform me about my right to represent before the detaining authority itself as well as the central government, your Lord. That has not been done. Then your Lordship will find, your Lordship, that on 16th May 2025, that is at annexure page 49, your Lordship, annexure 4, your Lordship, I was, your Lordship, informed about the grounds of arrest, grounds of detention. And your Lordship will find in 3rd paragraph of this order, your Lordship, this communication, again, they have informed me about my right to represent, your Lordship. You are also hereby informed that you have the right to make representation against the detention order to the government of Assam and also the advisory board constituted under Section 9 of the National Security Act, your Lord. Now, your Lordship will find the grounds of detention with material particulars. That is at page 51. May I read, your Lordship? Page 51. Lordship. There, your Lordship, so far as this grounds of detention are concerned, Your Lordship, the first ground, they have said delivery of seditious and inflammatory speech. On 23/4/2025, during a Panchayat election campaign held in village Jammuguri, Atinugani under Zuria police station, you have delivered a public speech in which you allege that the Puma terrorist attack 14/2019 was a conspiracy by the government of India. You further claim that the Pahalgam attack was also orchestrated internally by Indian authorities. These statements were factually baseless and publicly disseminated through social media platforms and press channels. Video recordings of this speech were circulated widely and have been preserved by law enforcement agencies for forensic verification. The material has been forwarded to the Cyber Cell Nagaon for authentication and analysis. Your speech created deep communal unrest and significantly disturbed the public peace and order, warranting the registration of Nagaon PS case number so and so under section so and so. This has already been negated by the order of the learned trial protocol. The certified copy of the FIR, one video recording of your speech as enclosed by the Superintendent of Police and reports from local police from the basis of material relied upon. Then dissemination of anti-national and communally provocative content. You were observed to have shared and endorsed inflammatory content on social media in recent months, including during COVID-19 pandemic, and it challenged the legitimacy of the Indian state and its counter-terrorism framework. Notably, during COVID-19 lockdown 2020, you circulated a post linking COVID positive individuals in Assam with the Tablighi Jamaat, claiming they were falsely implicated. A video claiming central government exported PPE kits and ventilators abroad, while doctors in India remain unprotected. A narrative suggesting government used COVID as a means to defend Muslim community. Misleading content alleging collusion between NDTV and certain religious organizations to protect Muslims as responsible for the pandemic spread. Those posts were found to have originated from your verified Facebook handle and were subject to investigation under CID PS case number 05/2020, dated 6/4/2020. Screenshot and post metadata were recovered and mentioned in the police dossier. These acts amount to indirect support for enemy narrative and tend to promote enmity between groups and diminish the credibility of democratically elected entities. Pattern of conduct threatening public order and state security. The above incidents are not isolated. You have previously been cautioned under the preventive section of law, and your continued conduct establishes a pattern of behavior aimed at provoking unrest and undermining constitutional authority. Your arrest on 24/4/2025 at 3:34 p.m. and subsequent remand on 25/4/2025 further confirm your active involvement in the instigating tension in a sensitive context. The law enforcement authorities have assessed that your release would pose a serious and immediate threat to public order and state security. Police intelligence reports and confidential dossier complied by the Superintendent of Police Nagaon have been relied upon in arriving at this conclusion. Satisfaction of the detaining authority. Upon careful consideration of the material on record, including FIRs, intelligence input, detailed evidence, I am satisfied that your activities are prejudicial to the maintenance of public order and to the security of the state. I am further satisfied that ordinary law is insufficient to prevent you from continuing such acts. Your preventive detention under Section 3(2) of the National Security Act 1980 is necessary. Right to representation. You have right to make a representation to the government of Assam and to the advisory board under Section 9 of the National Security Act 1980. Such representation may be submitted to the Superintendent of Central and Nagaon. We may also request a personal hearing before the advisory board. The communication is being in strict compliance with the provision of Section 8(1) of the National Security Act 1980, Article 22(5) of the Constitution of India. Now, enclosure, your lordship will kindly note, your lordship, FIR number 347. That is the FIR relating to the Nagaon PS case, your lordship. And then annexure 2, relevant excerpt from SP's dossier, including summary of CID PS case number so and so and related posts, your lordship. These are the only documents they have furnished to me according. Now, your lordship will kindly see the rationale for issuing detention order against Sri Aminul Islam at page 54. First paragraph, your lordship, I am keeping, your lordship. This is already, the second paragraph is important, your lordship. Here, that the above statements are dangerous, and by making these allegations, Mr. Islam has spread disaffection against the government of India and created hatred and mistrust among communities. In the aftermath of speech on 24th April 2025, there were reports of protest and communal tension as reflected in the intelligence input attached herewith. It is to be mentioned that soon after his video went viral on social media, certain comments, seditious and communal in nature and in tune with the contents of the video were spotted. For example, one person, namely Masoom Azahar, son of Sirajul Islam of Penal Bazar under Khatwal PS, District Nagaon, uploaded an objectionable derogatory comment targeting the Hindu community and threatened to oust them from the country. The person has been arrested in connection with Khatwal PS case number 16/2025 under section 152, 196, 299, 353C of the BNS. The arrested person has confessed to have been influenced and invoked by the very viral video statement given by Aminul Islam. Many other persons are making similar derogatory comments which have the potential to create communal tension in the state as well as the country. Moreover, certain comments mentioning Pakistani Zindabad, I love Pakistan and other similar nature are being circulated on social media as a fallout of the viral video of Sri Aminul Islam, screenshot along with link and post. This misleading and instigating statement having gone viral had the potential to create an adverse breakdown of public order and public peace in Assam. Such activities are prejudicial to the maintenance of public order and national security. Now, Your Lordship, pausing here for a moment, Your Lordship will find that this particular case, Your Lordship, relating to Khatwal PS case, Your Lordship, this is has an important bearing in my detention, Your Lordship, apparently from the rationale given by them. But copy of this, Your Lordship, FIR, Your Lordship, and the other documents relating to this case is not been furnished to me. And in fact, Your Lordship, while passing the detention order, Your Lordship, I can show from the affidavit of the detaining authority, he has also not gone through the particulars of materials of this particular case, Your Lordship. That means, Your Lordship, he has relied on what the police has, the SP has furnished to him in this particular rationale, Your Lordship. Independent application of mind, Your Lordship, is not there, Your Lordship. That is why, Your Lordship, I will show from the affidavit filed by the detaining authority that these documents he have never gone through, Your Lordship. Then, Your Lordship, para 3 and 4, Your Lordship, again, Your Lordship. This is, I am skipping, Your Lordship. Then, Your Lordship, will kindly come to page 56. There is a reference of around 23 cases, Your Lordship.
Record, ma'am. Which record, ma'am? Otherwise, all documents we have filed along with our affidavit.
Order is being passed by the detention authority.
Hmm.
So they and at least the what you call the advisory board were given their recommendation. At least those two records would be necessary.
Advisory board report came later. Detention order was earlier in point of.
No, because this here they give the rationale of why it has been done. Thereafter, this detention orders are passed. So what are the materials based on which they have taken a decision? So if you say so, if you're saying that there is no other, but this we go by that.
No, if any other record which we have and we have not furnished, we will furnish, no difficulty.
In
But
fact,
as far as detention order is concerned, the document based on which this detention order was passed, a satisfaction was arrived at. Those documents are more or less here only.
It's okay.
If anything is
we take your
required,
submission.
we'll bring, no difficulty.
in fact, Your Lordship, in para 6 of the affidavit filed by the respondent number 4 detaining authority, he has made a categorical statement that these are the documents he has annexed it also, Your Lordship, along with the affidavit, based on which the order has been passed. Now, Your Lordship will find that, Your Lordship, that these are the 23 cases, Your Lordship, which they have referred to in para 56, Your Lordship. Page 56, Your Lordship. Page 56 of my petition.
56.
56. These are the 23 cases, your lordship, they have referred to your lordship, and out of these 23 cases, your lordship has fined, your lordship, they have hard copies only in respect of Nagaon PS, your lordship, and there is a reference to your lordship, 3 cases, your lordship. And CID, your lordship, CID cases, we have been furnished copy, your lordship. And so far as rest of the cases, your lordship, no materials has been furnished to me, and the state government, they, while rejecting my representation, your lordship, in fact, take note of these 23 cases. There is a specific reference to these 23 cases, your lordship, by the state government in their order rejecting my.
Which is at page 53, which is the number 1, FIR 347. This is case number.
This is Nagaon PS case, your lordship. In
No,
which
Nagaon
case-
also there are 3 cases of Nagaon.
Nagaon,
Page
your
56.
lordship,
Which one?
Your lordship will, Nagaon PS, your lordship will. In page 53 or 56, your lordship.
Page 53, there are 2 documents which are supplied to you.
Lordship.
We want to identify this with the case numbers at page 56.
347. This was given to us, your lordship, and in so far as this 345 is concerned, your lordship, there is no reference to this, your lordship, in this particular list, your lordship.
So if you have understood you correctly,
Lordship.
we are at page 53, serial number 1, annexure 1,
Lordship.
copy of FIR number 347.
7.
You are trying to tell us that this is in addition to page 53.
Lordship, these are, your lordship, in addition to that Nagaon PS case number 347.
Now, this is annexure 2,
Lordship.
the excerpts of the SP dossier.
Lordship.
The dossier is not here.
Dossier, your lordship, will get later, your lordship. At page 60, your lordship.
60.
This has been provided to us. In dossier, your lordship, they have, your lordship, talk about, your lordship, 3 affairs. One, the recent one, in which case I was under detention, the first one. Second one is, your lordship, 877 of 2020, 5 years back, your lordship. And other one is also CIDPS, 5 years back. And the FIR of the CIDPS case number was provided to, CID case was provided to us, your lordship.
This is at page 56, serial number 1
Lost.
is FR file.
505 of 2020, your lordship. That is, your lordship. Your lordship will get it at
No,
page.
whether it is there or not.
Lordship.
FR has been submitted or not
FIR is furnished.
against you.
Lordship. And not their FIR not submitted, your lordship. That is pending.
That is pending.
Pending. We have no idea, your lordship, what happened. To our knowledge, your lordship, in 5 cases, FR has been submitted, which has not been accepted yet, your lordship. by the learned court.
Which cases?
In these cases, your lordship, one is Dibrugarh PS case number 290 of 2020.
Yes.
Then your lordship, Totasil PS case number 51 of the 2019.
Yes.
Kopu PS case number 311 of 2020.
Yes.
Simologuri PS case number 179 of 2021.
Yes.
And Amguri PS case number 39 of 2020. And Tinsukia PS case number 1901 of 2006. Six cases, your lordship, to our knowledge, your lordship. But those were not accepted by the till date accepted by the learned court. It's still pending in the. And even in CID PS case PS case, your lordship, there is no charge against me till date. And so far as this is, I have specifically pleaded this in para 29, page 32 of my writ petition, your lordship. There is no denial to that by the either of the authorities. And then your lordship will get from 66 on page 66 onwards, the newspaper reports. Your lordship, these are newspaper reports. How this can be incriminating, your lordship, that does not reflect, your lordship, which has been furnished to me, page 66, your lordship, onward. One is, your lordship, regarding my arrest, your lordship, published in one news, and then second one is also regarding my custody, police custody, your lordship, at page 68 and page 69, your lordship. This is a news report, your lordship, again, your lordship, of my arrest, your lordship. Only news report, your lordship, but I was arrested, your lordship. Then page 72, your lordship, Indian Express, your lordship. It again says, your lordship, held for sedition over Pahalgam remark, Assam MLA in eye of a storm, who is Aminul Islam, your lordship. And page 75 is a news report, your lordship, related to 2020 coronavirus outbreak, your lordship, when I was arrested. Now, these were, your lordship, the news report which it shows, your lordship, that I was arrested in these two cases, your lordship. Apart from that, your lordship, how this can be any incriminating material for, your lordship, subjective satisfaction of the detaining authority, your lordship, that cannot be inferred neither from the detaining order nor from the, your lordship, dossier they have furnished, your lordship, rationale they have furnished, your lordship, or from the affidavits, your lordship. Now, your lordship will find page 76 onward the Facebook posts, your lordship, by different persons, your lordship, in my wall, your lordship, Facebook wall, your lordship. And these, your lordship, will find, your lordship, I have not found anything, your lordship, incriminating here, your lordship, based on which, your lordship, it can be said that my statement has created such an impression among my followers that they have started making statements like Pakistan is Zindabad, your lordship. That is, I have at least not found, your lordship, subject to correction, your lordship. And there is one, your lordship, statement which is, your lordship, somehow, your lordship, offensive in nature. That is at page 78, your lordship. And this is an independent statement, your lordship. How to connect this to my statement, your lordship, there is no material. Page 78, your lordship. This is absolutely offensive, your lordship. But, your lordship, connect this to me, your lordship, there is nothing, your lordship. Now, your lordship will find they have marked Now, your lordship, to tally this, your lordship, with the what the detaining authority has stated in their affidavit, your lordship can take up their affidavit for a moment of the detaining authority. This formed by Debasis Sharma, your lordship, para 6, your lordship. May I read your lordship? That with respect to the statements made in para 9, para number 5 of writ petition, deponent respectfully states that a report was received from the superintendent of police Nagaon by memo number so and so, detained number so and so, dated 2/5/2025, along with the supporting lordship. Your lordship will kindly see from page 164 to 192, your lord. 164 to 192 of the affidavit, your lordship. That is annexure 2, your lordship. Page 135 to 161. 35 to 161. Exactly the same documents, your lordship, he said he has relied on, and these are the documents furnished. 135 only, your lordship. Fine. Annexure 2, your lordship. 135 to 161. your lordship. Annexure 2 of their affidavit, your lordship. These they have annexed, your lordship, exactly this 61. 62 is the detention. 161 is the document, your lordship, exactly the same document which I have shown, your lordship. Now, these are the documents they have relied on, they have, your lordship, based on which the detaining, the order of detention was passed, your lordship, and these are the documents, your lordship, furnished to me, your lordship. Now, your lordship will kindly come to page 80. This is the representation submitted by me, your lordship. This page 80 is my representation, your lordship. This was dated 22/5/2025 and received by the Central Jail on 23/5/2025. I have taken grounds on this, your lordship. I will not probably go through, for the sake of brevity, your lordship will not go through the entire representation. This is my representation, Your Lordship. Then Your Lordship will kindly come to page 86. 86. This is the order, Your Lordship, by which Your Lordship my detention was approved by the Governor. 25th of May 2025. Then it was communicated to me, Your Lordship. And my representation was also on 4th of June 2025 forwarded to the advisory board. Your Lordship. And Your Lordship will find, Your Lordship, at page 89. Page 89. Your- This is Your Lordship, important, Your Lordship. By this or letter, Your Lordship, dated 4th of June 2025, the district magistrate forwarded my representation to the government. Your Lordship. Now, from 23rd to 2000 to 4th of June, it took 12 days for the detaining authority to forward my representation, and there is no explanation in the affidavit as to 12 days. In fact, Your Lordship, our High Court has held, Your Lordship, even in case of 7 days delay in forwarding the representation, Your Lordship, will be fatal if there is no proper explanation. I will rely on that. I will show that. Now, Your Lordship will find at page 90, another letter, Your Lordship, dated 7 June 2025, by which Your Lordship District Magistrate informed me about my right to submit, Your Lordship, representation before the central government. Page 90. That is after, Your Lordship, 15 days of my detention. In fact, Your Lordship, in my representation, Your Lordship, I have made a specific prayer, Your Lordship, stating that it is requested that the present representation be placed before the advisory board or any other competent authority under National Security Act for their consideration and appropriate orders. Even without informing me, Your Lordship, they could have sent it forwarded to the central government, Your Lordship. It is the central government which pointed out to the state authorities that you should inform the detainee about his right to submit a representation, and that has been done, Your Lordship, 15 days after the date of detention, Your Lordship. Then Your Lordship will kindly come to page 92, Your Lordship. This is the corrigendum. Now, after all this has happened, Your Lordship, after around 28 days, Your Lordship, they found that they have committed a typographical error in the original detaining order. Page 92, Your Lordship. May I read, Your Lordship, this corrigendum? In reference to the detention order number so and so dated 14 May 2025, issued under section 3(2) of National Security Act 1980 against the Army Commissioner MLA TLS town of so and so, the following correction is hereby made to rectify the typographical error in reference notification number and date. The paragraph in whereas Government of Assam in exercise of the power conferred under section 3(3) of National Security Act 1980 has by notification number so and so dated 14/10/2023 delegate the power under section 3(2) of the State Act to the District Magistrate Nagaon shall be replaced with, and whereas the Government of Assam in exercise of the powers conferred under section 3(3) of the National Security Act 1980 has by notification number PLA so and so dated 28/2025 delegated the powers under section 3(2) of the State Act to the District Magistrate Nagaon. Assam, all other terms and conditions of the original detention order dated so and so shall remain unchanged and full force. And in fact, Your Lordship, it means, Your Lordship, that when the original order, detention order was passed, Your Lordship, it was based on a non-existent, Your Lordship, notification, which they sought to be cured through this order, corrigendum, Your Lordship, and in my humble submission, in a case relating to national security, preventive detention under National Security Act, slightest of infraction of law will be enough to vitiate the Your Lordship detention, and this is an infraction which cannot be cured by terming it as a typographical error, Your Lordship. Then Your Lordship will kindly see, then Your Lordship, on this date, Your Lordship, 12 June, they have furnished me a copy of that, the notification. Admittedly, Your Lordship, this document, they ought to have served on me, Your Lordship, on the date when the detention order was passed, Your Lordship, that they have not furnished to me, and that I have taken an ground in my representation, and that has been furnished to me on Your Lordship on 12 June 2025, after everything is over, Your Lordship. And then, Your Lordship, my submissions before the page 94 is my submission before the advisory board, Your Lordship. I have taken the grounds. An additional representation was also submitted, Your Lordship, after this corrigendum was issued, Your Lordship, to both the authorities, Your Lordship. And then, Your Lordship, page 116, Your Lordship. This is the 3rd of July, Your Lordship, page 116. in exercise of the power conferred under section 12(1) of read with section 13 of the National Security Act 1980, the government of Assam on the basis of report of the advisory board at their order number so hereby confirms the detention order number so and so dated 25/5/2025 passed by the additional chief secretary of Assam Government Political Department Dispute, detaining Sri Aminul Islam so and so Northern Assam for a period of 1 year from the date of detention. Now here, your lordship, this order, your lordship, does not reflect reasons for which, your lordship, I need to be confined for, detained for 1 year. Your lordship. That reasoning is not there in this, then purely mechanically, they have passed this order without proper application of mind to the material. And Honorable Apex Court has said, your lordship, that such order for detaining a person for 1 year cannot be passed without giving some reasons, your lordship. And recent judgment. Lordship. It says, your lordship, for passing such an order, your lordship, detaining a person for maximum period, there will have to give some reason by the authority. That is absent in the instant case. Now, your lordship will kindly take up the affidavit filed by the para 6, your lordship has seen, your lordship, already gone through. And so far as, your lordship, my representation is concerned, your lordship, para 21, your lord. May. In fact, Your Lordship, in para 23 of my writ petition, I have specifically raised the issue of delay. I have, there is also an inordinate delay in forwarding the representation petitioner to the advisory board as well as the prospect government. It will be pertinent to mention hearing that while the representation has filed petition on 23/5/2025, but the representation was only forwarded to the competent authorities on 4/6/2025 after 11 days of the submission of representation. There is no explanation as regard first cause of delay. In spite of that, Your Lordship, while replying to this, Your Lordship, in para 18, the detaining authority has only stated that the statements made in para 23 of the writ petition are not admitted by the deponent. Your Lord. There is no explanation as to why this delay has been caused. In spite of getting ample opportunity to explain the delay, Your Lordship, they have not explained it. And Your Lordship will then kindly come to para 29 of my writ petition, Your Lordship. Here, Your Lordship, from 29 1, Your Lordship, if Your Lordship permits me to read this paragraph, Your Lordship. Only one paragraph I would like to read, Your Lordship. No, Your Lordship,
Correction of date of birth. My lord. My lord.
till date, Your Lordship, I have not filed.
We used to rely on one judgment of Arnam Singh or something in connection with those correction of date of birth. My lord. Yes. Correct my date of birth.
Lord. 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 Page 27, para 29 of my writ petition. First part I am skipping, Your Lordship. The petitioner begs to elaborate on this contention through the following points. Your Lordship, page 28, Your Lordship. It starts from page 27, but Your Lordship, I am page 28. Your Lordship. The petitioner begs to elaborate on this contention of the following point. The most significant incident in the chain of events leading to the detention of the petitioner is the public speech wherein he had made certain distasteful comments critical of the central government in connection with the unfortunate terrorist attack at Pahalgam. The petitioner has sought to criticize the government of India for not placing any security for the tourists at Pahalgam. Nevertheless, for the comments of the petitioner, the Nagaon PS case number 347 of 2025 was lost against the petitioner on 24/2025, and he was arrested. The petitioner was thereafter released on bail by a competent court of law on 14/5/2025 on the finding that there had not been any untoward incident arising from the petitioner's speech. Then, when a court of law upon perusal of all materials on record has rendered such a finding, there is clearly no justification for the respondent district magistrate Nagaon to act hastily and issue an order of detention of the petitioner under National Security Act 1980. It reflects clear high-handedness and extraneous reasoning passing the order of detention. Moreover, the transcript of speech was also not given to the petitioner. He was handed a compact disc apparently containing a video recording of the speech, but the petitioner was in jail when such CD was given to him. He did not have any means to view such video. Para 29, Your Lord. Moreover, then one of the grounds of detention was that the petitioner had shared and endorsed inflammatory content on social media in recent months, including the COVID-19 pandemic that challenged the legitimacy of the Indian state at its counter-terrorism framework. Specific reference were made to social media activity of the petitioner during the COVID-19 period in 2020. It was stated that posts of the petitioner were subject of investigation in CID case number. So in this regard, petitioner most importantly begs to submit that social media post activity referred to by the detaining authority was not furnished to the petitioner, leaving him handicapped from making any representation in relation to the aforesaid allegation. Moreover, no documents to show the status of the investigation of CIDPS case number 5/2020 was furnished to the petitioner. the petitioner begs to submit that to the best of his knowledge, the investigating authority has not submitted any search sheet in connection with the aforesaid case, despite a lapse of more than 5 years since the institution of the case. This itself reflects the innocence of the petition. Now, your lordship, these are I have made specific averments to that effect, your lordship, that these are the documents they have not furnished to me, your lordship. And in para 32, your lordship will find that I have referred to those cases where, to my knowledge, final report has been submitted, your lordship. And your lordship, to this, your lordship, the detaining authority, your lordship, has replied in para 21 of their affidavit, your lordship. And para 21, page 127, it says that with regard to statements made in para number 28, 29, and 30 of the writ petition, the deponent denies that the grounds of detention reflect malicious intent of the detaining authority, and there is no bona fide exercise of the provisions of law while passing the detention order. It is also denied that due to lack of documents, the petitioner could not file an effective representation. In this regard, the deponent states that all documents relied by the detaining authority has been duly submitted to the petitioner, your lord. Now, your lordship has seen from page paragraph 6, your lordship, the documents he has himself has said that these are the documents I have relied on. Now, in those documents, your lordship, one most important vital documents relating to Khatwal PS case was not there, your lordship. Although there is a reference to around 23 cases, it was incumbent upon the detaining authority to go through all these documents to arrive at his subjective satisfaction, your lord, to pass the order detaining the petitioner, your lord. Now, your lordship, admittedly, those documents were not considered at the relevant point of time by the detaining authority, nor they were supplied to the detaining, your lord, so that he can file an effective representation before the authority. Had those documents been submitted to him, your lordship, the decision of the government or the advisory board may have been different, your lord. There was a possibility, your lord, but that has not been done, your lord. This is the affidavit, your lordship. Even in the affidavit opposition filed by the government, your lordship, they have not stated about the disposal of the representation, your lordship. But your lordship, it is their duty to your lordship to specifically state and to explain also the delay, your lordship. But your lordship will find from the note, your lordship, from there, these documents I have find out, your lordship, para 4 of the, your lordship, soft written note I have furnished, your lordship. Your lordship will find 2025, the representation was submitted, received on 23rd. 4/6/2025, it was, your lordship, forwarded to the government. On 10/6/2025, your lordship, district magistrate submitted his views, and from 10, then 25/6, the order has been passed, your lord. Now, in between 4/6 to 10/6, from 22/5, 23/5 to 4/6, then 4/6 to 10/6, what happened, what transpired, that is not explained, your lordship. And then on 10/6/2025, after submission of the report by the district magistrate, your lordship, which is normally in all NSA cases they take, your lordship, then from 10/6/2005 to 25/6/2025, what happens, that has also not been explained in their affidavit. Completely silent here. In this affidavit by the government, they have only annexed what they are already annexed by the detaining authority, your lordship. More than that, your lordship, factually they have not submitted anything. Your lordship will kindly come to para 33 of the affidavit filed by the government, your lordship. para 33, your lordship. That with respect to the statements made in para number 35 to 38 of the writ petition, deponent denies the correctness of the same and further makes to state that while issuing the detention order in exercise of power under section 3(2) of the National Security Act 1980, the determining authority relied upon only para 33, page 261, your lordship, of the affidavit filed by the government. Respondent number 2. Respondent number 2, your lordship. That with respect to the statements made in para 35 to 38 of the writ petition, the deponent denies the correctness of the same and further makes it stated while issuing the detention order in exercise of power under section 3(2) of the National Security Act 1980, the detaining authority relied upon the police records, relevant reports, past history, and the recommendation of the Superintendent of Police Nagaon, and being satisfied, prima facie case has been made out against the petitioner, past the detention order. That means, your lordship, those materials they have relied on. They have in their lordship affidavit has, your lordship will find the report of the advisory board, your lordship. Your lordship will page 301. That is about order of the advisory board dated 12/6/2006. This is your lordship. I have no comments to make on that. It's the order passed during the proceeding of. Rather than that, your lordship. Now, these are the factual circumstances relating to the case. Now, coming to this, your lordship will kindly So far as the factual part is concerned, it's simple. Now, Your Lordship, my part. Now, Your Lordship, so far as Your Lordship, my first ground is Lordship, as has been Your Lordship, I have pointed out from the order of the detention. Then the authority, the detaining authority has not informed me about right to represent before the detaining authority. Now, Your Lordship, this has been held by this honorable court. Lordship, maybe. At the end of the day, Your Lordship. To that, Your Lordship, I will say that Your Lordship, while Your Lordship, before this honorable court and also as a detainee, Your Lordship, I am not as a lawmaker, Your Lordship. Ultimately, as a citizen, Your Lordship. And Lordship.
Selective hearing. Selective hearing.
But at the end of the day, it is Your Lordship, it is his duty to inform me. The duty is cast upon the detaining authority. So Your Lordship, in fact, Your Lordship, for that, I have relied on one judgment, Your Lordship. Not one, Your Lordship. Lordship.
I was just thinking, let him complete. I'll give my reply tomorrow so that I can,
That is there.
Mr. Mazumdar, there will be some difficulty. Next week I am not here. I have to be outside for some work. So therefore,
outlying bench.
yes. And therefore, we come to the last week, which is very difficult for the purpose of hearing. So this is something we can't do by video conferencing.
Yeah.
Not very difficult.
Then immediately thereafter, 16th Tuesday, first Tuesday. First,
It's suffering from retention. That's the problem.
yes.
The urgency is lost.
But next week this bench is not.
Just see how much far you can go ahead. Okay? So you reserve your further submissions, just give the indication of the case paragraphs of the cases you have. That
That is your lordship, one is your lordship, I have your lordship mentioned.
you have given the paragraphs,
I have given the paragraph, that's the volume in which.
that will do,
There are two volumes, your lordship.
that will do. If you are hearing Mr. Mazumdar, I think to the other members of the bar, we cannot take up other matters then.
Item 20. On Monday, Tuesday, I'll be out of appeal. So maybe taken on next week, after 19th. Monday, and Tuesday, I'll be in Ijol bench. My number is 20.
Okay, just
Lots,
next Thursday, we'll give it to you.
lots,
Next Thursday.
lots.
Yes,
In fact, your lordship, in one judgment, your lordship, that your lordship kindly note your lordship, that is 2001 DLT 275, that's a full bench judgment of it. Of which I just bench of this honorable court has decided the issue relating to your lordship right to inform the petitioner about his right to represent before the detaining authority.
which one?
That is your lordship. That is your lordship. 2006 1 375 your lordship. It page 141 to 157 of the volume 1. It has relied on.
This is what you were told about that right. You were not told about the right of
Before the detaining. I have been told about my right to represent before the state government and the advisory board. So far as the detaining authority himself, that is an issue, your lordship, whether the detainee is required to inform about right to represent before the detaining authority himself or not. And it has been held, your lordship, that since detaining authority has power at the given point of time when issuing that order to revoke the order of detention, therefore he is duty bound to inform the detainee about the right to represent before the detaining authority. That your lordship will get it at page 141 to 157, your lordship. This is your lordship, you will find your lordship, this one.
Okay, we take note of it. Let Mr. Mazumdar begin, otherwise we won't be able to complete.
It was very specifically your lordship held.
We'll take note of that.
Lordship. No, your lordship, that exact para, your lordship, the line, your lordship, I will point out to you. The detaining authority under constitutional obligation to inform the detainee of his right to make such representation to the detaining authority, your lord. It has been held. The failure to inform the detainee of such right to make representation to the detaining authority vitiates the detention order made even under the provision of the National Security Act 1980. This is the specific finding by the 5-judge bench of this honorable court. Even it has relied on your lordship in judgment 1995 451, Kamalesh Kumar Ishwardas Patel versus Union of India. That is also part of that.
We'll take note of it.
Lord.
Let him begin. Yes.
Madam.
The detention order is at page 47, what you have seen, madam.
Yes.
My lord, in the in the writ petition, the challenge to the detention order has been made on certain grounds, which your lordship will find at paragraph 7, at page 9 of the writ petition. And in this paragraph, my lord, they have basically raised various issues, including the issue of not supplying the documents, then the notification by which the district magistrate was authorized to issue the detention order in terms of section 3, subsection my lord, 3 is concerned, my lord. There was a wrong reference of the notification number and date. Otherwise, notification is there of 2025 that has been subsequently modified. They have taken one ground to assail the detention order. Then fourth is very important. Fourth, they say the detaining authority has completely misled and misapplied the law of preventive detention and has passed the order of detention with complete non-application of the mind to the relevant facts. No, it's- And the detention order is based on irrelevant considerations which are not germane to the issue of the grounds on which a detention order can be passed, and therefore the grounds are vague, non-existent, irrelevant, etc., etc. And in the 8th paragraph, they have also said about the proximity of the incidents which have been taken into consideration. According to them, there is no proximity. I'll show my how and why there is proximity. Then they have also said about the illegality in the recording of satisfaction for issuing the detention order. And all the documents which were taken into consideration to arrive at the satisfaction were not furnished to them. These are basically the grounds. Other things, there are certain things about which the record will speak. I cannot improve something, whatever is there in the record. But so far as the satisfaction is concerned, which is the main issue, my lord, is concerned, for that, my lord, I'll take the lordship to certain things, my lord. The affidavit just been
We
filed by
also have a query to you,
my lord.
It's lingering in our mind for quite some time.
My lord.
That's why we asked the secretary to come here and we'll ask him a question.
My lord.
To the detainee you provided,
My lord.
city. Correct. So we just asked him that in this building, for use in our context, not
My
the bar.
Yes,
We have about 100 computers
computed. Yeah,
in this building,
my lord.
and none of them have CD drive.
I think CD player nowadays.
So it has come back. It has come back. CD is coming back in CD is coming back. Don't worry about that. But the fact is that in our computers we don't have it. So therefore, the gentleman who thought of giving him a CD, how does he expect a detained person in the jail to view the CD? Unless you have an entertaining system provided to all the.
My lord, to be very pragmatic about it, my lord. even if the grounds which are supplied to him for the purpose of writing representation, he will not write. He will communicate with his counsel and his counsel will write, although we have the duty to provide him the grounds immediately. In the custody, it will not be very easy for him to write the representation, take into consideration the ground. He will instruct his lawyer to read it, prepare it. Similarly, my lord, if something is there, if the CD contains something which was used against him, we have to provide it to him. I think pen drive was also given, no? Okay.
It says CD.
Okay, oh, my,
In the affidavit, you say CD.
my, yeah.
Speech.
Ah. Ah. There are two CDs contain, first one is about his speech. We have got pen drive also.
Very clear, tell you,
My lord.
where does he hear it? Because little while ago, because he could not communicate properly with the person filing the affidavit or the advocate,
My lord.
the issue of that representation which disposed of or not arose.
My lord.
You are giving a person who the liberty you are confiscating by giving him a city. If that it is required to be played here, we cannot do it. If
My
he has
lord.
to see what is the material against him to instruct, he has to see that
My lord. Absolutely.
the lawyer will find out his own story. He has to look at the city.
My lord.
The absence of that particular material, that this is the speech you get. Allegation is you did not even give a transcript. The allegation is that you did not even give a transcript.
Or
So
so
in
far as,
that situation,
my lord.
which are the words which are found not correct or which may be the words, how does he?
My lord, so far as the obligation of supplying him the materials based on which the detention order was issued, it is the obligation of the detaining authority to supply him. Now, after supplying, if it is within his possession, and then he says, in order to use it, to see it, I want some
He is given
apparatus.
he is given it in the language, he is given it in a language he does not understand.
Yes.
Then the very well the stand can be taken that if he did not understand English,
Yes.
he should have asked for translation. Why the obligation to give a translated version in a language he understands? So that he does not have to run around.
That will be a different thing.
So the
About so,
moment you give him a pen drive and
Right.
then he has to ask for.
and otherwise, if there is a video clip, in what form do I supply it to him? I can give him a computer.
The transcript of what he has said. These are the things you said. It is a speech.
His speech.
Yes. So what did he say? This is what you said, and we are agreed, or we are not satisfied with this speech. That has not been told to him that these are the words we are not happy with.
And so far as his speech is concerned, he himself has given the speech. It is not a speech of some other person, that some material has been used, some record has been maintained. And he is not saying that, see, I have not delivered any speech. It is not his stand. The only thing is I have to supply the speech to him. It's a video clip, audio video clip. I understand, my lord, what your lordship is raising question. But otherwise, how do we give it? And so far as his contents of the video clip is concerned, audio, it is there in the documents we have given.
Okay.
What he said, that we have given. Lordship, kindly come to.
Okay, please continue on your what you were arguing.
No, but
Just something which came up in the middle.
My lord, your lordship has put a query. I have to show that what he was supplied. Your lordship is absolutely correct that whatever material that was used for arriving at a satisfaction, it should be supplied to him. There is no absolutely difficulty in accepting the proposition of law. These materials, what he said, etc., were given in various forms, from starting from page 54. Lordship will find. Read petition only. This comes under the while supplying the grounds of detention from page 51 onwards. Page 54, Lordship will kindly see. While under the heading rationale for issuing detention order against the so-and-so, on so-and-so, Aminul Islam, while addressing a public gathering, made statements to the effect that we have given. Statements to the effect that Pulwama attack of 2019 and the recent Pahalgam terrorist attack were orchestrated by the central government leadership. This is the allegation. This is what is there in his speech. He accused the Honorable Prime Minister and the Honorable Minister of a conspiracy in these attacks. These statements were recorded on video and widely circulated on social media. That the above statements are dangerous, and by making these allegations, Mr. Islam had spread disaffection against the government of India and created hatred and mistrust amongst communities. In the aftermath of his speech on 24th of April 2025, there were reports of protests and communal tension as reflected in the intelligence input attached herewith. It is to be mentioned that soon after his video went viral on social media, certain comments, seditious and communal in nature and in tune with the context of the video, were spotted. For example, one person, namely Masum Azhar, son of Sirajul Islam of Penal Bazar under Khatwal PS district Nagaon, uploaded an objectionable and derogatory comment targeting the Hindu community and threatened to oust them from the country. The person has been arrested in connection with Khatwal PS case number so-and-so under section so-and-so of BNS. The arrested person was confessed to have been influenced and invoked by the viral video statements given by Sri Aminul Islam. Many other persons are making similar derogatory comments which have the potential to create communal tension in the state as well as in the country. Moreover, certain comments mentioning Pakistan Zindabad, I love Pakistan, and others of a similar nature are being circulated on social media as a fallout of the viral video of Sri Aminul Islam. Screenshots also, along with links, are enclosed. The misleading and instigating statement having gone viral had the potential to create an adverse breakdown of the public order and public peace in Assam. Such activities are prejudicial to the maintenance of public order and national security. So in the video clip, the reliance was placed on certain statements, as your Lordship is seeing. And those statements we have stated here, saying that this was what we addressed. Your Lordship is absolutely correct, my Lord. Whatever material has been relied on ought to have been supplied to him. Now we are saying that in the address, in that CD, whatever we have relied is this. Then, my Lordship, at page 54, the second paragraph, my Lord. That say Aminul Islam, being the public figure MLA, wields considerable influence and his utterances carry weight. There is a high likelihood that he will continue to make such inflammatory statements and thereby exacerbate communal fault lines and anti-national sentiments if he remains free. His detention has become essential to prevent him from acting in a manner prejudicial to public order and the security of the state in the near future. The normal legal provisions are not sufficient to immediately prevent the harm from his actions. See, Aminul Islam is currently in judicial custody and is in process of obtaining bail. Granting of bail could lead to him continuing in indulgence of public provocation and inciting violence and hatred among public at large. Although an FIR number so-and-so at Nagaon police station has been registered against him, the process of prosecution will take time, and there is an imminent need to stop him from further public provocation. There is a reliable information that his reporters are planning more events and he has shown no remorse. Thus, invoking the National Security Act is necessary to neutralize the threat he poses. Hence, for the reasons stated above, I am satisfied that it is necessary to detain Sri Aminul Islam under the National Security Act 1980. This action is taken to prevent him from continuing to incite disaffection and communal disharmony which pose a serious threat to public order and the security of the state. Then, my lord, the background we have given here, next page, and then the future threats we have given. What is more important is at page 60 of your lordship kindly sees. There are three specific police case registered. One is Tuar Nagaon and one is CIDPS case. There again we have narrated what are the materials, why it has become necessary to detain him under the National Security Act. Now, and the sections, provisions of law of IPC and BNS, which are mentioned here, your lordship will find, I have found out, my lord, 197, so far as BNS is concerned, 197, 1133, 352, 353, these all deal with national integration, threat to national integration, prejudicial to national integration, breach of peace, public mischief. Then IPC, again, national integration, section 153A, 124A, sedition, and then 295A, deliberate and malicious act insulting religion. Then thirdly, my lord, the CIDPS case number 5 of 2020, again 153A, 1A of IPC is there. In this, my lord, page 60, lordship will find what we have relied on. Upon receipt of written FIR from informant, namely Inspector Debojit Das, OC Nagaon PS, stating that an information has been received that Aminul Islam, member of Legislative Assembly representing Dhing LSC, has made public statements there that are seditious, misleading, and potentially detrimental to the unity and integrity of our nation. A video circulating on social media and press platforms featuring Aminul Islam accusing the central government of India of orchestrating the Pahalgam terrorist attack. And a member of Legislative Assembly making a statement with regard to the incident which has recently taken place in Pahalgam, and he is saying that it has been orchestrated by Government of India. He is a member of Legislative Assembly. He is a part of the government in a state. And the entire world knows this is a terrorist attack. He says it is an attack by the Government of India. Then, my lord, I am just reading it further. Orchestrating the Pahalgam terrorist attack, which was perpetrated by Pakistan-sponsored terrorists and resulted in the death of 28 innocent individuals. Moreover, a public speech was made on April 23, 2025 during a Panchayat election campaign meeting held in village Jamuguri, so under Juria police station. Sri Aminul Islam publicly alleged that the Pulwama attack on February 2019 was a conspiracy by the Government of India again. And its key functionaries. These statements are not only factually incorrect, but are also intended to incite public unrest by spreading misinformation and hatred, undermine the authority and legitimacy of the democratically elected central government, divert attention from the involvement of Pakistan in terrorist activities, thereby directly supporting an enemy nation. And thereafter, in the Facebook post, there are replies, there are comments. Well done, good job. So this is not inciting, then what is this, my lord? Number of comments. Then next comes page 60, my lord, the PS case number 877 of 2020. Complaint, this is with regard to Corona 2019, madam. Complainant Sri Swenso, son of Swenso, has lodged an FIR on 6/4/2020 at 6 p.m. against Sri Aminul Islam MLA Dhing LSC, stating that accused is trying to create communal riots among different religious communities. Accused has sent an audio clip to various persons stating in the audio clip that the coronavirus COVID-19 treatment is nothing but a conspiracy to kill Muslim persons. This is the extent to which a member of legislative assembly goes. And in all the three FIRs, the petitioner has made an allegation that there is no proximity. In all the three, line is same. Religion on the one hand and attack the central government on the other. Incidents are completely different, nothing to do with the government. Corona, my lord, throughout the world, it is an admitted fact that it affected the entire globe. And we are saying it's to kill Muslim. Corona, nobody had any control. To kill Muslim persons by poisoning them in the name of treatment. Accused alleged Assam state government as well as health department of Assam of hatching a conspiracy of annihilating Muslim persons in the name of coronavirus COVID-19.
No, whether these are materials which should be enough
Yeah.
or not is one aspect of.
My lord. I'm talking about the
Me-
proximity part, my lord. My lord. No, your lordship has a query, my lord.
So what I was trying to find out is whether the technical grounds that he has taken,
My lord.
can they be addressed first so that we.
My lord, so far as
Because he's
technical,
saying that the incident of 2020
my lord.
backfire
Yes.
has no proximity with the
My lord, that is
detention now.
my lord, that is the query of the honorable court and the allegation of my the petitioner I am replying to now. In all the three, my lord, FIR in respect of all the three incidents, Pulwama attack, then Pahalgam attack, then Corona, line is same, allegations are same against the state. That is why there is proximity, my lord. Three incidents are not different from each other. Everywhere you attack the central government, whereas the attack is coming from across the border, then you say that no, it is orchestrated by the government. You are directly attacking the security and helping a foreign nation, that to enemy nation matter, not a friendly nation. Line is same. That is why there is proximity. That is why I'm saying my line is same. Allegations are of same nature. Every incident happens, the person picks up that incident for the purpose of doing the same thing. So that is why there is proximity, and that is why there is a need to invoke the provisions of National Security Act. When you are posing threat to the security of the nation in the name of religion and in the name of anything you see necessary, you divide the nation in the name of religion. You say that it is only to attack. Coronavirus treatment is only to attack Muslims. Is he saying that for coronavirus treatment, only a particular section of the country were given treatment and not others? Hindus were not given any treatment. No, same medicine. So how can we say, madam, there is no proximity? In 2009, maybe may it be 2020 or 2019 or 2025? And that is why there is my humble submission, proximity is absolutely there. And the nature of provisions under which the cases are registered, you will find almost in all the cases similar. Then, my lord, I just point out to your lordship while replying to at page 79, lordship will find one thing, my lord. Page 79 of this affidavit in opposition by respondent of 4, my lord. I'm sorry, madam. I'm sorry, madam. This is read petition. Read petition, page 79. Yes. Okay. My lord, in this, the page, my lord, links of different media coverage. Those videos which were supplied by CD, my lord, is available here also. In a mobile also one can play, my lord. Link is there. Page 79, my lord.
No, these are news links.
Yes, my lord. So those videos are there, my lord.
Hindu.
So far as, my lord, my lord, this argument with regard to the issuance of subsequent corrigendum to rectify a part of the order, saying that no, we have wrongly mentioned about one particular notification of 14th of October 2023, but it is actually a notification of 28th of February 2025, and correction has been made of the detention order by a corrigendum of 12th June 2025. And on this basis, manner, an argument has been made. Let's see, because of this, the detention order itself was bad. It was a non-existent order, number one. Number two, they say there is no provision in the National Security Act for amendment of the detention order. These are the two arguments made in respect of this. My reply is very simple, my lord. Your lordship will see this notification of 28th of February 2025 has been annexed at page 93 of the writ petition itself. Next page. And this is the notification whereby the government authorizes the district magistrate also under section 3, subsection 3 of the National Security Act to pass an order of detention as is given under section 3, subsection 2. Section 3(2). So, my lord, when power, had there been no power and subsequently by a different notification, power is sought to be invoked, then this argument can be a valid argument. Otherwise, my submission will be no prejudice has been caused for mentioning a wrong notification when a notification was already existing as on the date of passing of the detention order. And it is not a notification only in respect of the district of Nagaon, it is in respect of other districts also. Whereas having regard to the circumstances prevailing in and likely to prevail in the districts of Kachar, Sribhumi, Hailakandi, Dima Hasao, then Karbi Anglong, Dibrugarh, Tinsukia, Sibsagar, Jorhat, Golaghat, etc., etc. There are 35 districts. Nagaon is 26. Serial number 26 is Nagaon. The Governor of Assam, being satisfied that it is necessary to do so, hereby directs that the district magistrate of all the above districts and commissioners of police Guwahati, if also satisfied, as provided under subsection 2 of section 3, the National Security Act, exercise the powers conferred by the said subsection in any area within their respective local jurisdiction beyond 28th February 2025. My lord.
You're tentatively fixing it on next Tuesday, then we. 23rd.
My lord.
23rd of September, then we see if we can take it up.
Yes.
Just say the submissions of Mr. S. Bhattagul and counsel for the petitioner is concluded or reserving right to reply. So he has submitted a written note containing list of dates and the cases cited relied upon by him. Next para, the submissions of Mr. D. Mazumdar, an additional advocate general, assisted by Mr. D. Nath, a senior government advocate, remains inconclusive. Next part, Mr. K. Parashar, and a CGC is present. List on 23/9/2025.
Wah, maaf. Oh, kita diri. Court 20. Hmm. Wah, ini. Beliau perlu macam tu. Bikin kes pada orang konflik politik. Baru ini